पार्टी सब मिलकर एक हो गए, मगर प्राप्त क्या किया? दोनों ने सिद्धांतों से समझौता किया और कांग्रेस ने भी इतना सयाना दांव चला कि इन्होंने अगर उनका हाथ पकड़ के दिल्ली अध्यादेश पर समर्थन लिया हो तो अविश्वास प्रस्ताव ले आए, लीड उनको मिल गई। तो इसलिए मैं कहना चाहता हूं अंत में कि इन लोगों को आखिर में क्या प्राप्त हुआ, ये पंक्ति कह के समाप्त करता हूं कि इनको विधेयक भी नहीं मिला और सम्मान भी नहीं मिला, यानी इज्जत भी गई, बात भी नहीं मिली। तो एक पंक्ति कहता हूं, न तुम ही मिले, आप लोगों के लिए लागू है, न तुम ही मिले न मयस्सर तुम्हारी दीद हुई, दीद मतलब साइट, न तुम ही मिले न मयस्सर तुम्हारी दीद हुई, तुम ही कहो ये मुहर्रम हुई कि ईद हुई।
सुखेंदु शेखर रे, श्री सुखेंदु शेखर।
त्रिवेदी ने बड़े जोश के साथ और बहुत शेर शायरी के साथ उन्होंने बात की। त्रिवेदी ने शेर शायरी के साथ बहुत लंबी तकरीर की। अगर उसको उत्तर हमारे पास चतुर्वेदी है, अगर आप त्रिवेदी है तो हमारे पास चतुर्वेदी है।
माननीय प्रतिपक्ष के नेताजी, नहीं, डॉक्टर अभिषेक सिंघवी ने कवि का काम ज्यादा किया, वकील का कम किया। कितना कवि का काम आपने किया। श्री सुखेंदु शेखर रे, 9 minutes.
Thank you. I am not going to make a political speech because the matter relates to a very important bill relating to National Capital Territory of Delhi. Sir, there is no sound from this microphone. I cannot shout. No volume. No volume here.
I can hear.
But I cannot shout, sir. I cannot hear. There is no feedback. No feedback to my ear.
Yes, some problem, sir.
Good.
Some problem.
As I have stated, that I am not going to make any political statement, but my submission shall be confined within the parameters of this bill. On 19th of May this year, the Honorable President of India promulgated the Government of National Capital Territory of Delhi Amendment Ordinance 2023, which negates a Constitution bench judgment of the Supreme Court dated 11th May 2023 that brought services under GNCTD. There could be some symbolism in the ordinance being promulgated in the middle of the night, as already stated by some of my colleagues, just a few hours after the Supreme Court closed for summer vacation. But I am not on that. Meanwhile, the ordinance has been challenged in the Supreme Court, and the matter has since referred to a constitution bench. During the pendency of the matter before a constitution bench of the highest court of the land, the government has introduced this present bill to repeal the ordinance and for further amending the GNCT Act 1991. I wondered as to whether heaven would have fallen had the government waited for the outcome of the constitution bench where the ordinance is still pending. What is the urgency involved in the matter? What is the urgency? There is no whisper about the urgency in the bill or the statement which have been received just now after the introduction of the bill, that the aforesaid judgment, that is judgment dated 11th of May, posed certain challenges in the efficient administration of the government of NCT of Delhi, which needed to be addressed through appropriate legal interventions. According to me, this is a stigma on the highest forum of our judiciary, which must be deprecated by all conscious citizens of this country. Third, in the year 2021, in the matter of Madras Bar Association, the Supreme Court held inter alia, and I quote one line, "A legislation can be declared as unconstitutional if it is in violation of the principle of separation of powers, the rule of law, and Article 14 of the Constitution, that is arbitrariness." Therefore, once there is such a judgment, which was delivered in 2001, government ought to abide by that judgment of Supreme Court, which is otherwise a requirement under the Constitution. I am coming to that later on. Sir, the question is whether the Legislative Assembly of Delhi has powers over all matters in List 2 except the matters in entries 1, 2 and 18, which is public order, police and land. In apparent defiance of the 11th May judgment, this bill seeks to amend the GNCT Act for abridgment of the powers conferred upon the GNCT legislation by the Constitution, because the entry number 41 is sought to be taken away, is sought to be inserted through this bill, so 3 will be 4, rightly pointed out by our senior counsel, Mr. Abhishek Manu Singh Bichi. Now, sir, when a constitutional bench comprising 5 judges of Supreme Court declares or interprets Article 239 AA3A of the Constitution, the same is binding upon all courts and authorities in India in terms of Article 141 and 144 respectively. Neither Article 239 AA3A nor Articles 141 and 144 can be negated without a constitutional amendment. I repeat, without a constitutional amendment, this cannot be done. And if at all the government brings, subsequently will have to bring, if they wish, because this legislation will be declared null and void. As a student of law, I understand. It will be done. But if the government at all in future brings a constitutional amendment bill, that will also hit by the principle of separation of powers, and federalism, which are the basic structures of the Constitution that was held by the Supreme Court right from the Keshavananda Bharati case till Minerva Mill case. Yes. Sir, this bill this bill seeks to render the GNCTD Assembly, or for that matter the Delhi government, virtually toothless and ineffective insofar as the services and service commission are concerned. Even a constitutional bill on this score shall be unconstitutional ab initio, as it will negate federalism and separation of powers, already stated by me. Sir, now let me have a look at the bill once. Possibly that will be the final, because 7 minutes already elapsed. Come to part 4A. It says about provisions relating to the maintenance of democratic and administrative balance in the governance of National Capital Territory of Delhi. What a brilliant drafting. To maintain a balance, the original act came into being in 1991. We are in 2023. So for the last 33 years, there was no balance. There was no balance. That is why, all on a sudden, the Kumbhakarna has risen from the deep sleep to maintain a balance. Interestingly, the authority has been proposed to be created. Which authority? Already stated by other members. Your Chief Minister, Chief Secretary, Home Secretary. Sir, please give it to me. Please give it to me. Very interesting bill. Chief Minister, Home Minister, Chief Minister, Chief Secretary and Home Secretary. And whatever may be recommended by the Chief Minister, if it is not accepted by the 2 bureaucrats, then also it will be passed and the Lieutenant Governor will accept it. So, Chief Minister will be a, what should I say, what should I say, without any authority. He doesn't have any authority. The bureaucrat will prevail upon him. Sir, in democracy, will of the people is supreme. Vox populi, vox dei. Sabar upore manush satya tahar upore nai. Will of the people. But here, the will of the people, which has been reflected through election, the duly elected constitution elected government, his chief minister has no power, the bureaucrat will overrule the recommendations of the chief minister. This is a draconian bill. This is against all spirit of the constitution, and every citizen of this country should oppose this bill in the manner, not only inside parliament, even outside parliament, voice is to be raised. Sir, finally, with your kind permission, I would like to quote from a judgment online of former Chief Justice Y.V. Chandrachud, the father of the present Honorable Chief Justice of India. Quote, Parliament cannot, under Article 368, expand its amending power so as to acquire for itself the right to repeal or abrogate the Constitution or to destroy its basic essential features. Here is a case where the basic features are being destroyed. And sir, according to me, according to my party, All India Trinamool Congress, this government seeks to insert entry 41 of the list 2 into Article 239A3A, thereby expanding the scope of accepted matters so that the bill virtually stands against the heaven of freedom into which Rabindranath Tagore wanted his country to awake, as the bill reflects the abyss of unrestricted power to ensure emergence of a banana republic. Thank you, sir.
Shri Tiruchi Shiva, 14 minutes.
Thank you, Mr. Chairman, sir. Sir, I stand to oppose this bill very strongly, for it infringes upon the basic structure of doctrine by crushing the federalism, which is the soul of Indian democracy. Sir, this attempt of this government is yet another a strike on federalism. It is unwarranted, untenable, it is undemocratic, unjustifiable, unfederal, and unconstitutional. Sir, why I am saying all these things? Unwarranted. Sir, after 1991, when the Delhi was granted special status, BJP came to power. Mr. Madanlal Khurana and later Sahib Singh Verma, who were the chief ministers, they insisted for full statehood for Delhi. And later, sir, in 2003, August of 2003, the NDA-1 government introduced a bill insisting for full statehood for Delhi. So when they are ruling, they want full statehood for Delhi. Then what necessity for this ordinance or this bill, sir? At 2015, Aam Aadmi won the election with a significant margin. Immediately after that, the union government issued a notification that services will come under the control of the union government. And that sparked a legal battle, sir, which lasted for 8 years. And recently, the Supreme Court in 2018 and 2023 Constitutional Bench has given a unanimous judgment in favor of the Delhi government that they have got every power. Now this bill is attempting to overturn the Supreme Court judgment and override the powers of the state government. Sir, we should just look at it in this manner, sir. So whenever they are in double standard, when they are in power, they want something. It is intolerance, to say very shortly, if an opposition party is ruling, they will be disturbed by the governors. If it is a union territory, the lieutenant governor will take all the powers and will not allow the state government to function. So in this situation, where is democracy? Sir, our constitution, as you know very well, sir, has given a structure of federalism, which gives the very importance to the regional aspirations can be represented and realized by state governments, and which cannot be done by a centralized union government. Sir, it has also established a mechanism of triple chain accountability. The people hold the legislators accountable, the legislature holds the government accountable, and the government holds the officers accountable. But now, the officers are not under the control of the government of union territory. So what's the use of being there? So this triple chain accountability is broken by way of this attempt. This not only I say here, sir, the Supreme Court has also emphasized very strongly. It should not be severed on any account. Sir, now coming detail into the bill. Why we are opposing? What are the contentious issues? What are the reservations we have? All others have spoken, sir, but we have to enlighten it. Number one, this bill attempts to establish a National Capital Civil Services Authority. As everyone said, it will consist of 3 members under the chairmanship of the Chief Minister and 2 officers, Home Secretary and Chief Secretary. Who are they? Appointed by the Union government. Obviously, one can understand what will be the outcome. The quorum is 2 and the majority will be the decision. Sir, I have moved an amendment which even it may be passed. I think with hope. If at all it is passed, even it won't be of use, sir. Because even if the authority with a majority gives a suggestion to the lieutenant governor, he can reject it. So ultimately it goes there. The authority becomes redundant and the chief ministership becomes lesser than a rubber stamp. We are very sorry to say these words, sir. A chief minister elected by the government has to fulfill the obligations by the mandate is been given to him. But whereas he is not able to have control. Sir, Delhi has been the nucleus of power from Mughals to British. Can anyone say any ruler has ruled without control on their officers, whether he or she? But now this bill paves the way. Sir, where we are heading towards? The government which is accountable to the people, to the legislature, and the government which can hold the officers accountable, now they don't have any control over the officers. Number 2, sir, the Council of Ministers, the Cabinet. Earlier, sir, the notes which are prepared by the ministers. And it will be taken over there. And after the decision, it will be forwarded to the Lieutenant Governor. It is vetted by the Law Department. Now that the Secretary will overlook the Minister, and overall, the Cabinet, which is the Council of Ministers, if they take a decision, the Chief Secretary will come and say, it doesn't come under law or under the rules of procedure, and he will take it to the Lieutenant Governor who can alter it or reject it. So first, the Chief Ministership became redundant. Now the Council of Ministers become redundant. Number 3, sir. Any minister, if he takes any decision, the Secretary is the supreme. If the Secretary doesn't agree with the decision of the minister concerned, without the consent of the minister, he can take it directly to the Chief Secretary or to the Lieutenant Governor. So the ministership also becomes redundant. Number 4, sir. Delhi is also like other states run by some 50 around statutory authorities, corporations and commissions. This include industry, tourism, everything. It comes under even transport, water, sewerage, women rights, child rights and all. All these positions, the chairpersons and the members were earlier nominated by the government, by the Lieutenant Governor on the advice of the government. But now, sir, hereafter, these positions will be appointed only by the Lieutenant Governor. The government has to sit with folded hands. Sir, one by one, just though the authority is established, the authority has no say, and even in the authority, the Chief Minister has no say. Number 2, the Council of Ministers, the Cabinet becomes redundant, the Minister becomes redundant, Number 4, sir, all the commissions, all the corporations, all the statutory authorities will be appointed by the Lieutenant Governor, and then proroguing and summoning also comes to the power of the Lieutenant Governor. Earlier, sir, the Council of Ministers will decide a date and they will represent to the Lieutenant Governor and he will summon. Now that Lieutenant Governor can do. So the government cannot, if at all an urgent issue has to be resolved, if the Assembly has to be convened, the Chief Minister or the Council of Ministers has no power. Sir, kindly tell us. We are not just accusing the government or pointing fingers, what you are doing is wrong, but kindly explain to us why all these things happen. A government which has been elected by the people, they have to cater to the needs of the people. They only know the local people's aspirations. That's why we are pleading for state autonomy. When the voice for decentralization is going up and up, this government is traveling on the opposite direction. Powers are centralized in the union government again and again. What will happen? It will get broken. Sir, India, which is known for federalism, sir, everything is under threat now. Secularism is under threat now. Especially, sir, we are very much concerned that this bill again strikes at the very root of federalism. Sir, let me quote Dr. Baba Saheb Ambedkar. Ambedkar, in November 4, 1948, this bill disregards the constitutional morality. That's what I'm trying to drive at. Dr. Ambedkar on November 4th, 1948 in the Constituent Assembly, quote, while everybody recognizes the diffusion of constitutional morality for the peaceful working of a democratic constitution, there are two things interconnected with it, which are not, unfortunately, generally recognized. One is that the form of administration has a connection with the form of the Constitution. The other is that it is perfectly possible to pervert the Constitution. Sir, underscore. The other is that it is perfectly possible to pervert the Constitution without changing its form by merely changing the form of administration and to make it inconsistent and opposed to the spirit of the Constitution. Sir, it is not a statement by Tirthi Siva. It is Dr. Ambedkar in the Constituent Assembly. And emphasizing that, the Supreme Court in its judgment in 2018 refers to the Constitution in these words, quote, constitutional morality is that fulcrum which acts as an essential check upon the high functionaries and citizens alike, as experience has shown that unbridled power without any checks and balances would result in a despotic and tyrannical situation which is antithetical to the very idea of democracy. Sir, what is going on now? Unbridled powers without any checks. Everything is taken over. Sir, we are told now and then, again and again, many a time, that many of the acts that has been enacted during this regime, sir, are transgressing into the powers of the state governments. It is taking away the powers of the state governments. All are heaped with the union government. So this is what the Supreme Court has also said, unbridled power with no checks and balances. Same thing, Dr. Ambedkar has also told, constitutional morality, this disregards constitutional morality. Sir, I earnestly appeal to my fellow colleagues of some political parties who may support the government's decision. My earnest appeal, as Mr. Singhvi told, sir, we are living in an area where there are 100 huts, all thatched roofs. If the last house is burning, the person sleeping in the first house will not sleep. He will go, run and put out the fire with the fire brigade. Yes, it is not only to help him, sir, but to safeguard his own self. If it is not put out, that fire will slowly come and at last it will affect them. So it has to be thought over. Sir, all these years, we have preserved our independence. We have preserved our democracy. Sir, often you used to say, sir, very proudly, India, the largest democracy in the world. Yes, sir. The largest democracy now is in peril. Why so many charges against the state governments? No state government is able to function on its own. It's not able to enact a law. If something is passed in an assembly, it is not endorsed by the governor. So they are not able to serve the people's needs. Only they know what the people need. That's why the state governments have been formed. But now that either the union government encourages or through the governor, it is trying to obstruct. Sir, all these things have to be kept in mind. Again, I say, all the reservations and contentions we have raised are not with a partisan mood, sir, but it has to be justified. Why all these things have been done? Why all the powers have been taken from a state government? Why the chief ministership has been reduced to the level of, sorry to say the word, rubber stamp, and more or less, everything is redundant, sir. What is the big idea of getting along? Sir, let me conclude, sir. I've already told them once, now that, not in any other manner. In the democratic process, one day they will be out of power. And every day they will be lamenting and regretting for all those laws they have enacted. It is not far behind, sir. 2024, the India Alliance will win. We will be there. And, sir, we will restore Delhi its autonomy. Thank you very much.
Let me go on. Don't be too quick. It is not too quick for me. Shri Raghav Chadda, 14 minutes. 1-4.
सर, आज मैं सिर्फ 2 करोड़ दिल्ली वासियों की ओर से नहीं बल्कि 135 करोड़ भारतवासियों की ओर से बोलने के लिए खड़ा हुआ हूँ। सर, इससे ज़्यादा असंवैधानिक, गैर कानूनी कागज़ का टुकड़ा एक बिल के माध्यम से शायद ही आज से पहले कभी संसद भवन के भीतर लाया गया होगा। और अपना वक्तव्य शुरू करने से पहले मैं महाभारत के एक अंश का वर्णन करना चाहूँगा जिसे रामधारी सिंह दिनकर ने एक बहुत ही महत्वपूर्ण कविता में लिखकर बताया है, जिसमें भगवान श्री कृष्ण एक शांति दूत बनके पांडवों की ओर से हस्तिनापुर जाते हैं शांति का प्रस्ताव लेकर। कवि लिखते हैं, मैत्री की राह बताने को, सबको सुमार्ग पर लाने को, दुर्योधन को समझाने को, भीषण विध्वंस बचाने को, भगवान हस्तिनापुर आए, पांडव का संदेशा लाए। भगवान कहते हैं, दो न्याय अगर तो आधा दो, पर इसमें भी यदि बाधा हो तो दे दो केवल 5 ग्राम, रखो अपनी धरती तमाम, हम वहीं खुशी से खाएंगे, परिजन पर हंसी ना उड़ाएंगे। पर दुर्योधन वो भी दे ना सका, आशीष समाज की ले ना सका, उल्टा हरि को बांधने चला, जो असाध्य था उसे साधने चला, जब नाश मनुष्य पर छाता है पहले विवेक मर जाता। सर, इसमें दिल्ली बिल का सार है। सर, हम न्याय की गुहार लगाने आपके सामने आए हैं, अपने हक मांगने आए हैं, अपने हक से ज्यादा मांगने नहीं आए। सर, मैं अपने वक्तव्य को 3 भाग में बांटता हूं। पहला कि ये बिल कैसे एक राजनीतिक धोखा है, पॉलिटिकल फ्रॉड है। दूसरा, ये कैसे एक संवैधानिक पाप है, कॉन्स्टिट्यूशनल सिन है। और तीसरा कि ये एडमिनिस्ट्रेटिव लॉकजैम यानी कि प्रशासनिक गतिरोध दिल्ली में कैसे पैदा कर देता है। सर, पहला राजनीतिक धोखा, यह कहानी है सर 1977 से लेकर 2015 की। लगभग 40 साल का लंबा संघर्ष भारतीय जनता पार्टी ने दिल्ली में पूर्ण राज्य का दर्जा स्थापित करने के लिए किया। 1977 में जब 3rd मेट्रोपॉलिटन काउंसिल दिल्ली में था, उसमें जनता पार्टी की सरकार थी। उन्होंने मता पास कर कहा कि दिल्ली को पूर्ण राज्य का दर्जा बनाएंगे। लगातार पूर्ण राज्य की दर्जे की मांग करते करते ये 1989 का लोकसभा का मैनिफेस्टो में बीजेपी का लाया हूं। 1989 के मैनिफेस्टो में पेज नंबर 361 पे पॉइंट नंबर 10 पे ये कहते हैं, ग्रांट स्टेटहुड टू यूटी ऑफ दिल्ली। यानी कि 1989 से लेकर लगातार ये लोग दिल्ली को पूर्ण राज्य का दर्जा दिलाने की मांग करते रहे। यहां तक कि जब 1991 में कांग्रेस की सरकार ने दिल्ली में विधानसभा का गठन किया, उससे भी ना पर्याप्त मानते हुए लाल कृष्ण अडवाणी जी, मदन लाल खुराना जी सबने बयान दर्ज कराए कि यह भी दिल्ली के साथ न्याय नहीं है, दिल्ली को पूर्ण राज्य का दर्जा मिलना चाहिए और हम इसके लिए आंदोलन चलाएंगे। और लगातार इन लोगों ने
संघर्ष किया, आंदोलन किया। सर 1998, 1999 में फिर अपने मैनिफेस्टो में बीजेपी ने, ये 1999 का मैनिफेस्टो है, ये जारी कर कहा कि हम दिल्ली को पूर्ण राज्य का दर्जा देंगे। पेज नंबर 132, पॉइंट नंबर 31, वी विल गिव फुल स्टेटहुड टू दिल्ली। सर इन लोगों ने बड़ा आंदोलन चलाया, संघर्ष किया, सड़कों पे लाठियां खाई, न जाने क्या क्या किया दिल्ली को पूर्ण राज्य का दर्जा दिलाने के लिए। और अंततः वो दिन आया जिस दिन वाजपेयी सरकार और वाजपेयी सरकार के उप प्रधानमंत्री आदरणीय लाल कृष्ण आडवाणी जी इस सदन के भीतर एक बिल लाए, द कॉन्स्टिट्यूशनल अमेंडमेंट बिल 2003, जो दिल्ली को पूर्ण राज्य का दर्जा देता है। यह बिल आडवाणी जी इस सदन के भीतर लाए और कहा कि दिल्ली को अधिकार देने की जरूरत है, दिल्ली को पूर्ण राज्य का दर्जा भाजपा दिलाएगी। यहां भी बात खत्म नहीं होती सर। इसके बाद 2013 के अपने मैनिफेस्टो में बीजेपी ने कहा हम पूर्ण राज्य का दर्जा देंगे। इनकी जून 2013 में नेशनल एग्जीक्यूटिव की मीटिंग हुई, उसमें मता पास कर कहा हम दिल्ली को पूर्ण राज्य का दर्जा देंगे। यहां तक कि इनके सांसद डॉक्टर हर्षवर्धन ने बयान दिया कि जब आदरणीय नरेंद्र मोदी जी देश के प्रधानमंत्री बनेंगे हम दिल्ली को पूर्ण राज्य का दर्जा देंगे। ये इन सब ने सर लगातार बातें कही और दिल्ली को पूर्ण राज्य का दर्जा दिलाने की मांग लगातार भारतीय जनता पार्टी दिल्ली वालों के सामने रखती रही। सर ये बिल सिर्फ संविधान का और लोकतंत्र का अपमान नहीं है, ये बिल लाल कृष्ण आडवाणी जी का, अटल बिहारी वाजपेयी जी का, मदन लाल खुराना जी का, सुषमा स्वराज जी का, अरुण जेटली जी का, सबका अपमान करने का और उनके 40 साल के संघर्ष को मिट्टी में मिलाने का काम करता है। सर मैं माननीय गृह मंत्री जी का बयान लोकसभा में सुन रहा था। उन्होंने कहा कि नेहरू जी ने, पंडित नेहरू ने यह बात रखी थी कि दिल्ली को पूर्ण राज्य का दर्जा नहीं मिलना चाहिए। मैं माननीय गृह मंत्री जी से कहना चाहता हूं, नेहरूवादी मत बनिए, आडवाणीवादी बनिए, वाजपेयीवादी बनिए और दिल्ली को पूर्ण राज्य का दर्जा देने का आज आपके पास ऐतिहासिक मौका है। दिल्ली को पूर्ण राज्य का दर्जा दीजिए। सर इस बिल को लाने का असल कारण क्या है? यह बिल क्यों लाया गया है? पिछले 25 साल में दिल्ली में 6 बार विधानसभा के चुनाव हुए, 6 के 6 चुनाव भारतीय जनता पार्टी बुरी तरीके से हारी। यहां तक कि 2015 और 20 में आजाद भारत के इतिहास की सबसे बड़े जनादेश की सरकार अरविंद केजरीवाल ने दिल्ली में बनाई। क्योंकि ये पिछले 25 साल चुनाव नहीं जीत पाए और अरविंद केजरीवाल और आम आदमी पार्टी के आने के बाद ये जानते हैं कि अगले 25 साल भी ये लोग चुनाव नहीं जीत पाएंगे, तो सरकार को नष्ट करने का काम कर रहे हैं। ना रहेगी सरकार और ना रहेगा चुनावों का महत्व, ना रहेगा बांस, ना बजेगी बांसुरी। लेकिन मैं आज इस मंच से भाजपा से अनुरोध करूंगा कि कम से कम लाल कृष्ण आडवाणी जी को न्याय दीजिए, कम से कम उनकी इच्छा पूरी करिए, दिल्ली को पूर्ण राज्य का दर्जा दीजिए। सर मेरा दूसरा भाग कि कैसे यह बिल एक संवैधानिक पाप है। सर पहली चीज, ये अब्यूज ऑफ ऑर्डिनेंस मेकिंग पावर्स है, आर्टिकल 123 जो संविधान का देता है। संविधान ये कहता है, और वाईवी चंद्रचूड़ साहब का AK रॉय वर्सेस यूनियन ऑफ इंडिया एक बड़ा महत्वपूर्ण लैंडमार्क जजमेंट है, जिसने कहा कि ऑर्डिनेंसेस सिर्फ आपातकालीन और विषम परिस्थितियों में लाए जाएंगे। ऐसी कौन सी आपातकालीन और विषम परिस्थितियां आ गई कि आपको सुप्रीम कोर्ट के फैसले को 8 दिन के भीतर बदलना पड़ गया? दूसरा देखिए सुप्रीम कोर्ट की दूसरा बिंदु, यह सुप्रीम कोर्ट का अपमान है। सुप्रीम कोर्ट के फैसले को 8 दिन के भीतर 5 जजों के संवैधानिक पीठ के सर्वसम्मति के फैसले को बदल के आज भारतीय जनता पार्टी ने एक मैसेज दिया है कि हम सुप्रीम कोर्ट को भी चैलेंज करते हैं, सुप्रीम कोर्ट के फैसले को भी नहीं मांगते। आपको जो ऑर्डर जारी करना है करो, हम चंद दिनों के अंदर ऑर्डिनेंस लाकर उस फैसले को बदल देंगे। दे हैव चैलेंज्ड द मैजेस्टी ऑफ द ऑनरेबल सुप्रीम कोर्ट। सर और मैं आपको ये कहना चाहता हूं कि आजकल जो ऑर्डिनेंस लाने की जो एक फेटिश इस सरकार ने देखी, चाहे वो लैंड एक्विजिशन बिल हो, चाहे वो फार्म बिल हो, चाहे ईडी के डायरेक्टर का एक्सटेंशन हो, जो ये सारी चीजें ऑर्डिनेंसेस के माध्यम से इन्होंने करी थी, इस बिल का हश्र भी वही होगा जो सारे पुराने बिलों का हुआ था। सर थर्ड बिंदु कि कैसे ये बिल संघीय ढांचे को एरोड करता है। हमारा भारत का संविधान और सुप्रीम कोर्ट का 2023 का 2018 का संवैधानिक पीठ का फैसला कहता है कि दिल्ली के पास एक यूनिक फेडरल आइडेंटिटी है, यूनिक कॉन्स्टिट्यूशनल आइडेंटिटी है, और भारत का संविधान जो हमें संघीय ढांचा देता है, जो शक्तियां देता है, उन शक्तियों को एनक्रोच करने का काम यह सरकार करती है, हमसे अफसरशाही और तमाम शक्तियां छीनकर। मैं आपको सुप्रीम कोर्ट का वो एक वाक्य पढ़ के सुनाना चाहूंगा। द मेजॉरिटी इन द 2018 कॉन्स्टिट्यूशनल जज बेंच हेल्ड that while the NCT of Delhi could not be accorded with the status of a state, the concept of federalism is applicable to Delhi. हम पूर्ण राज्य नहीं है, लेकिन फिर भी राज्य का दर्जा एक संघीय ढांचे के परिप्रेक्ष्य में दिल्ली को मिलता है। उसके बाद सर इन लोगों ने तो कमाल ही कर दिया, आज बिना संवैधानिक संशोधन लाए संविधान को बदल दिया, मात्र एक एक्ट ऑफ पार्लियामेंट से, जो आज तक शायद भारत के इतिहास में कभी नहीं हुआ। सर इसके बाद यह बिल पार्लियामेंट्री अंडरमाइन करता है प्रिंसिपल्स ऑफ कलेक्टिव रिस्पांसिबिलिटी को। भारत का संविधान कहता है सर कि परमानेंट एग्जीक्यूटिव और पॉलिटिकल एग्जीक्यूटिव मिलके लेजिस्लेचर के प्रति जवाबदेही होंगे, ये प्रिंसिपल ऑफ कलेक्टिव रिस्पांसिबिलिटी है। इसमें से परमानेंट एग्जीक्यूटिव यानी कि अफसरशाही को छीनकर ये पूरी तरीके से कलेक्टिव रिस्पांसिबिलिटी का प्रिंसिपल जिस पे सरकारें चलती हैं इस देश में, उसे ध्वस्त करता है। और आखिरी बिंदु संवैधानिक अपराध का, ये ट्रिपल चेन ऑफ अथॉरिटी को तार तार करता है सर। ट्रिपल चेन ऑफ अकाउंटेबिलिटी ये होती है कि अफसरशाही की जवाबदेही मंत्री को, मंत्री की जवाबदेही लेजिस्लेचर को, और लेजिस्लेचर की जवाबदेही जनता को। इसमें से अगर आप अफसरशाही हटा देते हो तो फिर जवाबदेही की जो ये ट्रिपल चेन ऑफ अकाउंटेबिलिटी है ध्वस्त हो जाती है। तो ये काम करके संवैधानिक अपराध एक प्रकार से सरकार ने किया है। सर मेरा आखिरी भाग, ये कैसे एक एडमिनिस्ट्रेटिव हाराकिरी, एक एडमिनिस्ट्रेटिव गतिरोध पैदा करता है। ये कहता है सिर्फ उपराज्यपाल ही ट्रांसफर पोस्टिंग करेंगे एक समिति के माध्यम से, यानी कि अफसर अब मुख्यमंत्री के नहीं सुनेगा, मंत्रियों की नहीं सुनेगा। अगर अब दिल्ली में किसी के घर में बिजली नहीं आ रही, पानी नहीं आ रहा, किसी के बच्चे का स्कूल में दाखिला नहीं हो रहा, तो वो उपराज्यपाल के पास जाएगा, अपने मंत्री मुख्यमंत्री के पास नहीं जाएगा। क्या लोग जानते हैं उपराज्यपाल कहां रहता है? उपराज्यपाल कौन सी विधानसभा से चुनाव लड़ा, उपराज्यपाल ने कौन सा चुनाव जीता? लेकिन सारी शक्तियां एक चुनी हुई सरकार से निकालकर उपराज्यपाल को देता है। ये आगे कहता है सर ये बिल कि हम एलजी को सोल डिस्क्रिशन देते हैं, स्वयं के विवेक से फैसले लेने की तमाम शक्तियां। आज तक उपराज्यपाल और गवर्नर काउंसिल ऑफ मिनिस्टर्स की एड एंड एडवाइस से बाध्य थे, लेकिन यह बिल उपराज्यपाल को सुपरसीडिंग पावर देता है। आगे सर यह बिल जितने भी ब्यूरोक्रेट्स हैं उन्हें एक जुडिशियल अथॉरिटी बना देता है। यह कहता है अफसरशाही तय करेगी कि मंत्री का फैसला सही है कि मंत्री का फैसला गलत है, और अगर अफसर को मंत्री का कोई फैसला पसंद नहीं आया तो अफसर मंत्री का फैसला लागू करने से मना कर सकते हैं। और सर यह बिल अथॉरिटी, कमीशंस और कॉरपोरेशंस बनाने की, तमाम गठन करने की, नियुक्ति करने की शक्तियां सारी की सारी केंद्र सरकार को दे देता है, यानी कि सरकार की चाबी एक प्रकार से केंद्र सरकार को हाथ में पकड़ा देता है। सर माननीय गृह मंत्री जी ने कहा था कि आम आदमी पार्टी एक सुपारी सी जितनी पार्टी है, एक सुपारी जितनी छोटी सी पार्टी है। सर ये वो सुपारी जितनी पार्टी है जो आजाद भारत के इतिहास का फास्टेस्ट ग्रोइंग पॉलिटिकल स्टार्टअप कहलाती है। ये वो सुपारी जितनी पार्टी है जिसने 3 बार भाजपा को दिल्ली में हराया और 2 बार 2015 और 20 में आजाद भारत के इतिहास की सबसे बड़ी जनादेश की सरकार बनाई। ये वो सुपारी जितनी पार्टी है जिसने पंजाब में भाजपा को लगभग शून्य पर लाकर खड़ा कर दिया। ये वो सुपारी जितनी पार्टी है जो 10 साल में राष्ट्रीय पार्टी बनी। ये वो सुपारी जितनी पार्टी है जिसके 161 विधायक और 11 सांसद है। और ये वो सुपारी जितनी पार्टी है जिसका काम देखने के लिए फर्स्ट लेडी ऑफ यूनाइटेड स्टेट्स ऑफ अमेरिका और यूनाइटेड जनरल के पूर्व प्रमुख बान की मून आते हैं। सर मैं आज अपने साथी जो आंध्र प्रदेश और उड़ीसा की सरकार चलाते हैं उन्हें कहना चाहूंगा, आपकी जरूर कुछ मजबूरियां रही होंगी जिसके चलते आपने ये फैसला लिया इस सरकार के इस बिल का समर्थन करने में। कुछ तो मजबूरियां रही होंगी, यूं ही कोई बेवफा नहीं होता। लेकिन मैं आपको कहना चाहता हूं कि आग जब लगेगी तो बहुत दूर तक जाएगी। राहत इंदौरी साहब का एक बड़ा महत्वपूर्ण शेर है, अगर खिलाफ हैं होने दो, जान थोड़ी है, ये सब धुआं है, आसमान थोड़ी है, लगेगी आग तो आएंगे कई घर जद में, यहां सिर्फ हमारा मकान थोड़ी है। लेकिन जब आपके घर में आग लगेगी आम आदमी पार्टी आपके साथ खड़ी होगी, मैं आपको विश्वास दिलाता हूं। और सर मैंने अपनी बात शुरू करी थी महाभारत के एक अंश से, मैं समाप्त भी महाभारत के एक अंश से करूंगा। सर बीच कुरुक्षेत्र के मैदान में जब युद्ध प्रारंभ होने वाला था तो युधिष्ठिर ने शंखनाद करने से पहले एक घोषणा करी और कहा कि यह धर्म की लड़ाई है। मेरी सेना में खड़े मेरे पीछे जितने योद्धा हैं, अगर उन्हें लगता है कि धर्म मेरे साथ नहीं कौरवों के साथ है तो मेरी सेना छोड़कर सामने वाली मेरे दुश्मन की सेना में जाकर खड़े हो जाएं, उनकी ओर से युद्ध करें। और अगर कौरव सेना में कोई योद्धा है जिसे लगता है कि धर्म युधिष्ठिर के साथ है, पांडवों के साथ है, तो आप कौरवों की सेना छोड़कर मेरी सेना में आइए, मैं बाहें फैलाकर आपका स्वागत करूंगा। उस समय कौरवों का एक भाई युयुत्सु कौरव सेना छोड़कर पांडवों की ओर आया और पांडवों की ओर से युद्ध लड़ा। मैं उसी बात का जिक्र करते हुए आज इस सदन में बैठे तमाम सांसदों को कहना चाहता हूं, राज्यसभा काउंसिल ऑफ स्टेट्स है, हम लोग काउंसिल ऑफ स्टेट्स है, जहां ज्यादा जिम्मेदारी बनती है राज्यों के हकों की, अधिकारों की रक्षा करने की। मैं मांग करता हूं, आज आप लोग पार्टी लाइन से ऊपर उठकर, विचारधारा से ऊपर उठकर संविधान को बचाने के लिए, लोकतंत्र को बचाने के लिए इस बिल को हराइए। आज ये इतना असंवैधानिक और गैर कानूनी बिल अगर ये सफल हो गया तो हो सकता है आज के बाद आने वाले समय में ये लोग देश में चुनाव ही ना कराएं, चुनावी प्रक्रिया को खत्म करने से। बहुत बहुत शुक्रिया।
डॉक्टर सस्मित पात्रा,
Thank you.
12 minutes.
Honorable Chairman, sir, I rise to speak on behalf of the Biju Janata Dal. Sir, speaking on this bill in the Lok Sabha, our party's senior member of parliament and leader of the BJD parliamentary party in Lok Sabha, Shri Pinaki Mishra ji has already made our stand very clear and has made it very eloquently and succinctly expressed that the Biju Janata Dal's equidistant stand from the BJP and the Congress and the reasons for the same and the fact that BJP is our principal opposition party. I reiterate and place on record that we are equidistant from the BJP and the Congress, and our principal opposition party in Odisha is the BJP. Our stand today does not change anything in that regard. Sir, BJD is in favor of this bill because it supports the constitutional standpoint of this bill and the Parliament's power to enact legislations and the Parliament's legislative competence to such matters. Sir, I need your protection, sir. You can imagine the kind of ruckus being made. I should be heard. 4.5 crore people in Odisha want to hear, whether people here want to hear or not.
Honorable members, please keep calm.
Thank you, sir.
You see,
Sir, in July 4th, 2018, the Supreme Court judgment in its civil appeal has very clearly said on para 277, और ये मैं सुप्रीम कोर्ट के अध्यादेश या सुप्रीम कोर्ट के जजमेंट से रेफर कर रहा हूं, 2018 जुलाई 4, क्या कहती है सुप्रीम कोर्ट? Supreme Court in the matter of civil appeal 2357 says, however, if the Parliament makes laws in respect of certain subjects falling in the state list or the concurrent list, this is referring to Delhi, the executive action of the state must conform to the law made by the Parliament. ये सुप्रीम कोर्ट का जजमेंट है, मेरा नहीं है। तो ये पहला विषय है जो मैं आपके पास रखना चाहता हूं, why the Parliament has the legislative competence to bring something here. Second, 11th May 2023, sir, Supreme Court का judgment आता है in civil appeal again 2357 by Justice Chandrachud, Justice M.R. Shah, Justice Krishna Murari, Justice Hima Kohli and Justice Narasimha. Para 164 को मैं रेफर करना चाहता हूं, subsection C. What does the judgment say? In addition to the entries in list 1, Parliament has legislative competence, and I repeat, has the legislative competence over all matters in list 2 and list 3 in relation to NCTD, National Capital Territory of Delhi. तो ये दूसरा विषय है। 2018 के बारे में मैंने बोला, 11 मई 2023 का जो जजमेंट था सुप्रीम कोर्ट का, उसको मैंने उल्लेख किया। अब मैं तीसरे विषय पर आता हूं। जुलाई 20, 2023, अभी कुछ ही दिन पहले सुप्रीम कोर्ट का और एक जजमेंट आता है इन रिट पिटीशन 678 ऑफ 2023। ये आता है चीफ जस्टिस चंद्रचूड़, जस्टिस नरसिम्हा और जस्टिस मनोज मिश्रा का। एंड ऑन पेज 10, पैरा 17, ये जजमेंट क्या कहता है आखिरी पैराग्राफ में, और ये क्या विषय था मान्यवर? ये विषय था कि दिल्ली एनसीटी ऑर्डिनेंस जो है उसको जो है आप स्टे प्रोवाइड करें, सरकार को बोले कि दिल्ली एनसीटी ऑर्डिनेंस को वो कहीं ना कहीं से इंप्लीमेंट ना करें। दैट वाज द प्रेयर। तो माननीय सुप्रीम कोर्ट का जजमेंट आता है और आखिरी लाइन में सुप्रीम कोर्ट सेज, एंड आई कोट, IA number 13050 of 2023 seeking a stay of the NCT ordinance is dismissed. तो स्पष्ट तौर से सुप्रीम कोर्ट ये जो प्रेयर किया है एनसीटी ऑर्डिनेंस के बारे में, उसको डिसमिस कर देता है। तो ये जो बार बार कहा जाता है that the legislative power does not exist because the matter is pending, that is on a separate matter, not on the matter dealing with July 20th, 2023. तो फिर कॉन्स्टिट्यूशन बेंच के पास जो मैटर गया है वो मैटर क्या है? कॉन्स्टिट्यूशन बेंच के पास मैटर दिल्ली एनसीटी का नहीं गया है। क्या है? What are the contours of power of Parliament to enact a law under Article 239AA7, and whether the Parliament in the exercise of its powers under 239AA7 can abrogate the constitutional provisions of governance for NCT. So, Delhi Ordinance Bill specifically is not being placed before the Constitution bench. The points of law, जो दो points of law है, वो place किया गया है, ये स्पष्टता होनी चाहिए. Then I come to Constitution of India, संविधान पे आता हूँ. 2018 जजमेंट ऑफ सुप्रीम कोर्ट मैंने बोला, 11 मई सुप्रीम कोर्ट के बारे में बोला, 20 जुलाई सुप्रीम कोर्ट के बारे में बोला. अब मैं संविधान पे आता हूँ. संविधान धारा आर्टिकल 239AA सब क्लॉज 3B क्या कहता है मान्यवर? Nothing in subclause A shall derogate from the powers of Parliament under this Constitution to make laws with respect to any matter of a union territory or a part thereof. तो पार्लियामेंट को पूर्ण अधिकार मिलता है कि अगर आप ऐसी कोई भी लॉज आती हैं तो powers of the Parliament cannot be derogated, cannot be declined, cannot be diluted, cannot be taken away from the perspective of the powers to undertake their activity on any matter of a union territory. संविधान कहता है. अब constitution bench क्या कहेगा? That's a secondary issue. Now we come to 239AA, 7A and 7B of the constitution. मैं आखिरी पड़ाव पे हूं. अब कहा जाता है कि whether the parliament has the legislative competence. बीजू जनता दल पार्लियामेंट के साथ है, बीजू जनता दल कॉन्स्टिट्यूशन के साथ है, बीजू जनता दल that the parliament has the legislative competence to undertake such an activity उसके साथ है. So what does the constitution say? 239AA article clause 7A and 7B. What does 7A say, sir? 7A कहता है Parliament may by law make provisions for giving effect to or supplementing the provisions contained in the foregoing clauses and for all matters therein to or consequential thereto. इसका मतलब क्या है? सारांश बता देता हूं कि पार्लियामेंट के पास तमाम वो पावर्स हैं जिससे कि 239AA जो कि दिल्ली एनसीटी के बारे में है उस पर अपने रूल्स, अपने लॉज कर सकता है. 7B, any such law as is referred to subclause A shall not be deemed to be an amendment of this constitution. तो जो बात आती है बार बार constitution amendment की, clause 7B बहुत clearly संविधान का बताता है that this is not any changes in 239AA, 7A and 7B के तहत is not considered as a constitution amendment. It can be undertaken. माननीय अब मैं और 2-3 मिनट लूंगा और मैं खत्म करूंगा. So sir, this is a constitutional issue. This is a legislative issue. This is not a political one. This is an issue which is before the power of the parliament to legislate and its legislative competence. It's not about parties or governments. Sir, किसी ने कहा था, एक बहुत बड़े महापुरुष ने, एक बहुत बड़े लीडर ने, सरकारें आएंगी जाएंगी, पार्टियां बनेंगी बिगड़ेंगी, संविधान रहना चाहिए, इस देश का संविधान, इस देश की सोच रहनी चाहिए. Sir, with these words, and the matter is pending before the court, we would leave it at that. Let the constitution bench come back to it, but that does not take away the legislative competence of the parliament. We will continue our equidistant policy from both the BJP and the Congress, and Biju Janata Dal, led by our leader and Honorable Chief Minister Shri Naveen Patnaik ji, will continue to support the constitutional position and the parliament's power to enact this piece of legislation. Thank you. Jai Hind. Bande Utkal.
Thank you. Manya V. Vijay Sai Reddy. Reddy ji, you have 12 minutes. Please let him speak, please.
Thank you.
Please.
Thank you, Deputy Chairman, sir.
No comments while sitting on chair.
Sir, I, on behalf of my party and my Chief Minister Y.S. Jagannath Reddy Garu, raised to support this bill, and I need to respond in this regard while putting forth my arguments, observations. I will have to respond Manu Singhvi ji and also Raghav Chadda ji, who is not seen here. No.
Please, no.
Sir, the crux of the entire bill has to be understood in the light of the provisions of Article 239AA, as my colleague has pointed out, sir. Sir, 239AA Clause 3 has got 3 subclauses. Subclause A, Subclause B, Subclause C. Sir, Subclause A states, Delhi legislature has got the power to make the laws, insofar as the issues are concerned except public order, law and police. Sir, Subclause B states that Parliament shall have the power to make the laws with respect to any matter of for Delhi, any matter. Sir, the subclause C states that in the event of clash between the Delhi government and the Parliament, the law made by the Parliament shall prevail, and the law made by the Delhi government will become null and void. This is the Constitution clearly provides Parliament an upper hand when it comes to the making laws for Delhi. Therefore, the argument put forth by AAP and also the learned senior advocate Manu Singhvi ji observations are not will not stand before the law, sir. Then coming to the Supreme Court judgment, the second issue which I am dealing with, sir. Sir, on the issue, please. On the issue whether the Parliament can make the law on services in Delhi, that is the issue. The Supreme Court has categorically stated, quote in verbatim, the power of Parliament to enact the law granting government executive power over services is not in contention. It is now a settled position of law. So therefore, Supreme Court has not stated anything against the government or said any Parliament is not barred. Parliament is barred in making the rules in respect of services, sir. The second point, sir, hence on the issue whether Parliament can make the law to limit the executive power of Delhi government over services. In this regard, the Supreme Court has said, quote, sir, the executive power of Delhi government shall be subject to and limited to the executive power conferred upon by the central government, by the Constitution or law made by the Parliament, sir. So Supreme Court is very clear and very categorical, sir. The cumulative reading of these two observations of the Apex Court supports this bill. Therefore, YSR Congress Party supports this bill, sir. Sir, even the Supreme Court has noted in verbatim, sir, quote, the purpose of the Article 239AA is to confer expanded legislative competence upon the Parliament when it comes to the Delhi, since it is a capital of the country and therefore must be dealt with different considerations. This is what the Supreme Court judgment is, sir. Therefore, the arguments that have been put forth by Honorable Senior Advocate does not stand for judicial scrutiny, sir. Sir, I'll have to oppose I'll have to counter Chaddaji, Raghav Chaddaji, sir. There has been a lot of controversy surrounding the bill, sir. This controversy has been created only by Congress Party, AAP and other supporting parties, that is IA. And it is an attempt to mislead the public for their own selfish political gain, sir. Sir, Deputy Chairman, sir, please listen to me, sir. In fact, the very member of this August House, my friend Raghav Chadda ji has pointed out, sir, he has said, लगेगी आग तो आएंगे कई घर जद में यहाँ हमारा अकेला मकान तोड़े ही हैं. That is what he has said. Sir, I am responding to Raghav Chadda ji. He has also said that certain non-NDA parties are under compulsion and coercion to support this bill. That is what he has stated. Please stop it. ED may come to you also. Don't.
Please.
Sir,
please. please, no,
Sir, I would like to.
no, no,
Madam,
no
please.
cross-talk, please.
I would like to remind Raghav Chaddaji that the fire doesn't start just like that, sir. Fire doesn't start without fuel. It is Aam Aadmi Party which has put the fuel. That is the reason why whole confusion and the entire state of affairs which are prevailing now, sir. I would only advise the honorable member Raghav Chaddaji not to play with the fire, what he has referred to. Not to play with the fire, because the very fire which he has put forth may engulf, he himself may get engulfed in that, sir. Sir, it is clear, it is very clear that if this bill is passed, the Aam Aadmi Party, that is the official name, I have no hesitation to say that it is absolutely anarchy party, AAP. And to put it in Hindi, sir. Sir, no, I will not yield to you. No, sir.
Nothing is wrong. The record will be checked. Please,
Let them get an opportunity. Whenever they get an opportunity, they can speak.
please take your
I
seat.
will not yield, sir.
He is not here.
I am not
Please
yielding.
take your seat.
I am not yielding,
Please,
sir.
please continue your speech.
I will put one step forward and say, Tana Shahi Party. That is what they are doing now. Tana Shahi Party, anarchy party. What they are doing is that nothing but an anarchy, sir.
Please take your
Can
seat.
no longer Delhi for selfish and ulterior motives. Please. Sir, I have to bring to your kind notice. One of the observations made by one of their founder members, sir. Sir, one of the founder members of Aam Aadmi Party, famous personality, has categorically said, he was poet and he was very popular leader also, Kumar Vishwas. What did he say? What did he say? Sir, he has made an allegation that the convener of the party, that is Aam Aadmi Party, has supported separatists and collected funds from the separatists for the elections. That is what the state of affairs, sir. Sir, it is not me. It is not me who is saying this. It is the founder member of their party. It is the founder member of their party who has said it.
Please, you know, Mani, please. Raghav, take your seat.
Raghav Chaddaji,
Take your
I will
chair,
come
please.
to you. There are some more issues.
माननीय वी विजय साई रेड्डी जी,
Sir,
आप जानते हैं माननीय चेयरमैन ने कहा जो भी बातें आप
talking
कहते हैं
of bill
उसको
only, sir.
सब्सिट्यूट करना पड़ता है यहाँ पे।
Sir, I am talking of bill only.
जो आप कहते हैं उसकी रिस्पॉन्सिबिलिटी लेनी पड़ेगी।
Raghav Chadda has commented on YSRCP. That is the reason why I am responding to him, sir.
आपस में कमेंट ना करें, स्पीक ऑन द बिल प्लीज एड्रेस प्लीज
But
no comment.
we won't collect the funds from the separatists.
Please.
We have not collected the funds from separatists.
आपस में कमेंट नहीं, please address the chair.
Sir, I will respond to him appropriately, sir.
Please.
Sir, I would like to know why they need power. Why they need power?
Please.
Is it to support the separatists? Is it to support the anti-nationals? They require power. Please listen. Raghav Chaddaji, please listen.
Raghav Chaddaji, back to your seat.
देशद्रोह करने के लिए क्या? देशद्रोह करने के लिए क्या? I am asking you.
V. Vijay Sai Reddy ji, address.
Sir,
Your chair.
Sir, many members like me would like to know what happened to the founder members of Aam Aadmi Party, like Shanti Bhushan, Prashanti Bhushan, Yogendra Yadav, Kumar Vishwas, Ashutosh. What happened to them? It is their opportunistic politics, and because of that, they have backstabbed them, and then they have unseated them, and these people have captured the power, and it is a, and I have no hesitation to say, they don't fit to rule the Delhi government, sir. And finally, I would like to say one thing, sir, that Delhi is not belonging to Aam Aadmi Party. Delhi belongs to every citizen of this country. Every citizen of this country. Delhi, we have every right. And if at all something happens to Delhi,
Please go back to your seat. Please, दूसरे की सीट पर न बैठे. Please go back to your seat. Please. Address. Mani B. Vijay Sai Reddy ji, address to the chair.
yes,
please.
sir. Sir.
Or no cross talking.
Okay, sir.
Please.
We are. Sir, I am here to debate whether the bill is constitutionally valid, not the politics of Aam Aadmi Party, sir.
Right.
And the and whether the Constitution as well as the Supreme Court both have said that this bill is constitutionally valid and perfectly within the precincts of the law. Therefore, we support this bill, sir. I have not said anything against Aam Aadmi Party. I am just bringing it to the notice of this august house what their founder members have said. What their founder members have said. And I reiterate once again that absolutely anarchic party,
Mr. Pathak,
absolutely anarchic party can't act like this. Thank you very much. Thank you.
Thank you. Dr. Radha Mohan Das Agrawal.
माननीय उपसभापति महोदय, मैं दिल्ली राजधानी राष्ट्रीय राज्य क्षेत्र शासन संशोधन विधेयक 2023 के समर्थन में बोलने खड़ा हुआ। महोदय, इस दुनिया में 3 तरह के लोग होते हैं। एक वो जो कोई भी परिस्थिति हो सत्य बोलते हैं, सत्यवादी हरिश्चंद्र। एक वो जो हमेशा सत्य बोलते हैं, कभी कभी मजबूरी में असत्य बोलते हैं, नरोवा हस्ती, धर्मराज युधिष्ठिर। एक सामान्य नागरिक होते हैं जो मजबूरी में सत्य भी बोलते हैं, कभी कभी असत्य भी बोलते हैं। 2013 के बाद इस देश के राजनीतिक परिवेश में एक नया प्राणी उदय हुआ है, जो गीता पर शपथ लेकर कहता है कि मैं झूठ बोलता हूं, झूठा ही बोलूंगा और झूठा ही बोलता रहूंगा, मैं उसका नाम नहीं लूंगा। अध्यक्ष महोदय, 2014 में जब यह पार्टी सरकार में आई थी तो दिल्ली के व्यापारियों ने बड़े समर्पण भाव से इसका समर्थन किया था। दिल्ली के व्यापारियों के साथ इन्होंने एक बैठक की। बैठक में दिल्ली के व्यापारियों को कुछ सपने दिखाए। क्या थे वो सपने? हम रेडी टू यूज एंड शिफ्ट मार्केट बनाएंगे। 2014 एक भी मार्केट नहीं बना। उन्होंने कहा कि हम दिल्ली के सारे बाजारों को मॉडल बाजार बना देंगे। एक भी बाजार मॉडल नहीं बना। उन्होंने कहा कि हम दिल्ली के बाजारों को, चूंकि लोडिंग और अनलोडिंग नहीं होती है, हम रिलोकेट करेंगे। एक भी बाजार रिलोकेट नहीं हुआ। उन्होंने कहा कि हम दिल्ली में बिजली का बिल कम करेंगे। सच्चाई यह है कि कमर्शियल का बिल दिल्ली में सारे अधिभार को छोड़ करके सबसे अधिक है, पूरे देश में सबसे अधिक है। 9 रुपए से लेकर के 14 रुपए तक का बिल देना पड़ता है। इन्होंने कहा हम दिल्ली में आएंगे तो दिल्ली का विकास कराएंगे। 9 साल के इतिहास में अगर नितिन गडकरी न होते तो इन्होंने एक भी फ्लाईओवर दिल्ली में नहीं बनवाया है। इन्होंने दिल्ली के व्यापारियों से कहा 10 मिनट की बारिश में आपके यहाँ पानी लगता है, हम इसका इलाज कर देंगे। आज की स्थिति यह है कि 10 मिनट तो दूर, 2 मिनट भी पानी बरस जाए तो पुरानी दिल्ली पानी में डूब जाती है। इन्होंने कहा कि हम आपके हाउस टैक्स को, चुप रहो, इन्होंने कहा कि हम हाउस टैक्स को कम करेंगे। सच्चाई क्या किया इन्होंने? कमर्शियल टैक्स को 3 गुना किया। और उपसभापति महोदय, यह अकेला राज्य है जहां व्यापारी कमर्शियल टैक्स भी देता है और अपने दुकान के सामने का कूड़ा उठाने के लिए 500 रुपए से लेकर के 5000 रुपए तक का शुल्क भी अदा करता है। इन्होंने वादा किया था कि हम झोपड़ी झुग्गी वालों को पक्का मकान बना के देंगे। सच क्या है? भारत सरकार ने करोल बाग में 8,000 मकान बनाए और शिफ्ट किया। जब इनको मालूम हो गया कि झोपड़ी झुग्गे वाले इस पक्के मकानों में चले जाएंगे तो हम इनका शोषण करके इनका वोट नहीं ले पाएंगे, तब से लेकर आज तक इन्होंने भारत सरकार को दिल्ली में झोपड़ी झुग्गी के पक्के मकानों बनाने के लिए एनओसी तक नहीं दिया। अध्यक्ष महोदय, इन्होंने वादा किया था कि हम दिल्ली के 351 सड़कों को रेजिडेंशियल की जगह पर कॉमर्शियल परमिशन देंगे। सच यह है कि आज 9 साल हो गया, एक भी सड़क को इन्होंने रेजिडेंशियल से कॉमर्शियल में बदलने का काम नहीं किया। जब अभी चुनाव हो रहा था एमसीडी का, एक मुख्यमंत्री गाजीपुर के पहाड़ पर जाता है, कुतुब मीनार की ऊंचाई पर चढ़ता है, कहता है दिल्ली कूड़े से डूबी हुई है, एमसीडी हमको दे दो, हम दिल्ली से कूड़ा खत्म कर देंगे। और सच्चाई क्या है? बजट में व्यवस्था करने के बाद कितनी क्रूर है यह दिल्ली सरकार। इसने अपने ही एमसीडी के लोगों से कहा हमने बजट में व्यवस्था की होगी, लेकिन जो व्यवस्था 850 रुपए करोड़ की कूड़े को हटाने के लिए की है वो हम तुमको नहीं देंगे। अपने ही सरकार को इन्होंने पैसा नहीं दिया। अध्यक्ष महोदय, इन्होंने कहा था कि दिल्ली में व्यापारिक विस्तार करने के लिए हम झोपड़ी और हम ट्रेड फेयर लगाने का काम करेंगे। दिल्ली के व्यापारी आज भी इंतजार कर रहे हैं कि दिल्ली में कोई ट्रेड फेयर लगाने का काम ये लोग कर सकें। इन्होंने कहा था कि हम दिल्ली की यातायात व्यवस्था को बेहतर करने के लिए रैपिड रेल ट्रांजिट सिस्टम लाएंगे। 700 करोड़ रुपया खर्च करना था। अभी सुप्रीम कोर्ट ने कहा विज्ञापन पर 1100 करोड़ खर्च करने वाली ये सरकार दिल्ली के यातायात पर 700 करोड़ रुपए तक नहीं खर्च कर पाई। अध्यक्ष महोदय, इन्होंने इस प्रकार से दिल्ली के लोगों को धोखा दिया तो किया क्या? मैं बैठा था कोपू की बैठक में, अमर पटनायक जी हमारे मेंबर थे। उन्होंने कहा जल्दी जाइए, दिल्ली डूब रही है, पानी लग गया। मैं उठ करके भागा, मैं वेस्टर्न कोर्ट में रहता हूं, वहां पहुंचा। वेस्टर्न कोर्ट में पीने के लिए पानी नहीं था। मैंने पूछा ऐसा क्यों? बोला वजीरपुर सेंटर डूब गया, इसलिए पूरे दिल्ली को पीने का पानी नहीं मिलेगा। कैसी शर्मनाक स्थिति पैदा कर दी। पहली बार अध्यक्ष महोदय 2019 में 8 लाख क्यूसेक पानी छोड़ा गया था और दिल्ली में कोई भी बाढ़ नहीं आई थी। इस साल सिर्फ 3,59,00,000 क्यूसेक पानी छोड़ा गया और पूरी की पूरी दिल्ली डूब गई। इसलिए डूब गई कि इन्होंने काम भी नहीं किया। 2 साल तक सिंचाई विभाग की बोर्ड की इन्होंने बैठक नहीं की। बैठक की डेट तय की, दिल्ली ने मुख्यमंत्री ने आने का वादा किया, मुख्यमंत्री गायब हो गया। दूसरी महिला मंत्री पहुंची, वो भी गायब हो गई। आज तक इन्होंने दिल्ली को यमुना के बाढ़ से रोकने के लिए 9 साल की सरकार हो गई, किसी प्रकार की कोई व्यवस्था नहीं की। इन्होंने किया क्या? परिवहन बस घोटाला किया। इन्होंने किया क्या? उपराज्यपाल ने अभी 437 लोगों को निकाला है। कोई सलाहकार था, कोई रिसर्च फेलो था, कोई विशेषज्ञ था, कोई रिसर्च एसोसिएट था, कोई कंसल्टेंट था। और वास्तव में क्या था? कोई किसी विधायक का आसपास का था, उसका भाई था, कोई किसी मंत्री का रिश्तेदार था, कोई आप पार्टी का कहीं का कन्वेनर था। ऐसे ऐसे लोगों को इन लोगों ने आरक्षण के सारे नियमों को धता बताते हुए बिना प्रॉपर तरीके से 60,000 से लेकर के 1.5 लाख तक रुपए तक की मासिक वेतन पर रखने का काम किया। और सबसे बड़ी बात, दिल्ली के 150 ऐसे चौराहे हैं अध्यक्ष उप सभापति महोदय, जहां अगर आप जाएंगे तो आदमी अपने हाथ में तख्ती लेकर खड़ा रहता है दिल्ली के सरकार की उपलब्धियों को बताने के लिए। एक एक चौराहे पे 4-4 आदमी, उनको तनख्वाह दी जाती है 20,000, लेकिन चेक से दिया जाता है 4,000। ये 16,000 रुपया ये लोग उसको कहां से पैसा लाके देते हैं? शायद अगर ये बताते तो बहुत बेहतर होता। और अध्यक्ष महोदय, जिसका सबसे बड़ा ढिढोरा पीटते हैं, मोहल्ला क्लिनिक। अभी कर्नाटक के स्वास्थ्य मंत्री आए थे, इनके स्वास्थ्य मंत्री के साथ अभी वो एक मोहल्ला क्लिनिक देखने गए थे। देखने के बाद उन्होंने एक ट्वीट किया। वो ट्वीट आज भी उस मंत्री के ट्विटर हैंडल पर मौजूद है। और क्या लिखा उन्होंने? विजिटेड ए मोहल्ला क्लिनिक इन दिल्ली with hardly any people there। एक आदमी भी वहां नहीं था। आवर क्लिनिक इन कर्नाटका हैव मोर फैसिलिटीज इंक्लूडिंग लैबोरेटरीज टू बी इमीडिएटली टेस्टेड, यानी वहां पर हमारे कर्नाटक में ऐसी लैबोरेटरीज हैं जो तुरंत जांच कर लेते हैं। और आगे क्या लिखा, आई गेस इट इज ए ओवर हाइप्ड स्टैंड एंड आई कम बैक फीलिंग डिसअपॉइंटेड। यानी इन लोगों ने अध्यक्ष छोड़िए उन्हें,
मैडम
यानी
नो कमेंट।
उन लोगों ने ये कहा कि इन लोगों ने सिर्फ शब्द बयानी की है, झूठ बोला है, मुझे तो यहां से बहुत निराश होकर जाना पड़ेगा। और अध्यक्ष महोदय, जब कर्नाटक के स्वास्थ्य मंत्री यह कह रहे थे तो अभी तो जुमा 1 महीना उनको आए हुआ है, वो भारत के कर्नाटक की भाजपा सरकार की उपलब्धियों को बता रहे थे। अध्यक्ष महोदय, उपसभापति महोदय, अभी माननीय सिंधवी साहब यहां बोल रहे थे और हमसे बता रहे थे मार्गदर्शक मंडल की बातों को मानो, थोड़ी भी शर्म होती। आज अगर ऊपर कहीं सचमुच पंडित जवाहरलाल नेहरू जी बात सुनते होंगे तो शर्म के मारे उनकी आंखें डूब जाती होंगी। इस सदन को यह जानना चाहिए कि दिल्ली को राज्य बनाने के संदर्भ में पंडित जवाहरलाल नेहरू का स्टैंड क्या था। अभी तिरुचि शिवा साहब चले गए, डॉक्टर भीमराव अंबेडकर की चर्चा कर रहे थे। इस सदन को जानना चाहिए कि दिल्ली को राज्य बनाने में डॉक्टर भीमराव अंबेडकर का क्या स्टैंड था। संविधान सभा ने एक कमेटी बनाई थी, उस कमेटी का एक निर्णय आया पट्टाभी सीतारमैया कमेटी का। नेहरू जी इतने नाराज हो गए कि उन्होंने संविधान सभा की बैठक में जाकर कहा, अरे ये क्या बना के लाए हो, 2 साल में दुनिया बदल गई, दिल्ली की आधी से 3/4 संपत्ति भारत सरकार की होती है, हम दिल्ली को अलग राज्य का दर्जा कैसे दे सकते हैं। ये नेहरू जी की बात कह रहा हूं, अगर किसी सदस्य के अंदर हैसियत होगा तो मैं नाम लेकर कह रहा हूं, चुनौती देने के लिए वो खड़ा हो जाएगा। डॉक्टर अंबेडकर की बात इन्होंने कहा, अंबेडकर ने कहा, सो फार एज दिल्ली इज कंसर्न इट इज बेटर टू अस दैट एज ए कैपिटल ऑफ इंडिया इट कैन हार्डली बी प्लेस्ड अंडर द लोकल एडमिनिस्ट्रेशन। अर्थात जहां तक राजधानी का सवाल है, दिल्ली को स्थानीय प्रशासन के हाथ में कतई नहीं दिया जा सकता। यूएस कांग्रेस का पूरा नियंत्रण यूएस की राजधानी वाशिंगटन पर होता है, इंग्लैंड का, ऑस्ट्रेलिया का पूरा नियंत्रण कैनबेरा के ऊपर होता है। इस बात का कोई आधार नहीं है कि पूरी दुनिया में जहां कहीं भी देश की राजधानी में कोई शहर हो, उसे सीधे सीधे देश की राजधानी के नियंत्रण में रखा जाए। और अध्यक्ष महोदय, हुआ क्या, 1952 में सरकार बनी थी, चौधरी ब्रह्म प्रकाश पहली बार मंत्री बने थे और उसके बाद गुरमुख निहाल सिंह जी आए थे। कितने दिन वो रह पाए। नेहरू जी जानते थे जो हो गया है बहुत गलत हो गया है। उन्होंने स्टेट ऑर्गेनाइजेशन कमेटी बनाई फजल अली की, उस कमेटी ने अपनी रिपोर्ट दिया, बड़ी लंबी लंबी रिपोर्ट सिंधवी जी पढ़ रहे थे। एक छोटी सी रिपोर्ट मैं भी पढ़ देता हूं, जो स्टेट रीऑर्गेनाइजेशन कमेटी की मीटिंग में इस कमेटी ने दिल्ली के बारे में कहा। इन फ्रांस फॉर एग्जाम्पल देयर इज ए ग्रेटर डिग्री ऑफ सेंट्रल कंट्रोल ओवर पेरिस देन ओवर अदर म्युनिसिपैलिटीज। In England, the police administration of the metropolitan area are directly under the control of Home Secretary, who does not exercise similar power in respect of other municipal area. Apart from the regions which are peculiar to each country or city, there are some general considerations necessitating special arrangement in respect of national capital. Capital cities possess or come to possess some degree of political and social predominance. They are seat of national government. They are seat of national government. Any constitutional division of the power, if it is applicable to the unit functioning in the seats of national government, it is bound to give rise to embarrassing situation. और 1956 की इस रिपोर्ट को आने के बाद हम आभारी होंगे इस देश के प्रधानमंत्री का, चाहे जो भी नाम, उन्होंने अपनी ही पार्टी के मुख्यमंत्री को हटा दिया, दिल्ली की विधानसभा को भंग कर दिया और दिल्ली को पुनः यूनियन टेरिटरी बना दिया। अध्यक्ष महोदय, चर्चा हो रही थी 1991 के विधेयक की। क्या है यह विधेयक? मेरे हाथ में वो कागज है। जिन बातों की चर्चा माननीय विजय साई रेड्डी जी ने की, मैं उनको दोहराऊंगा नहीं। धारा 3 सब क्लास 3 के ABC को मैं तीसरे पर आता हूं, जिसकी चर्चा सिंघवी साहब ने की थी, यहां नहीं। वो कह रहे थे कि पार्लियामेंट मे बाय लॉ मेक प्रोविजन फॉर गिविंग इफेक्ट टू और सप्लीमेंटिंग द प्रोविजन कंटेन्ड इन द फॉरगोइंग क्लासेस एंड फॉर ऑल मैटर इंसिडेंटल और कॉन्सिक्वेंशियल देयर ऑफ। अध्यक्ष महोदय, अध्यक्ष महोदय, सभापति महोदय, वास्तव में ये जो विधेयक आया है वह दिल्ली के निवर्तमान विधेयक को सप्लीमेंट करने के लिए आया है। क्या प्राविधान है? 9 साल ये सरकार रहे, इन्हें मालूम था कि एंट्री 41 होती है, इन्हें मालूम था कि एंट्री 41 में लिखा हुआ है स्टेट पब्लिक सर्विस कमीशन, इन्हें मालूम था कि इनके सरकार में आने से लेकर 9 सालों तक दिल्ली में कोई स्टेट पब्लिक सर्विस कमीशन नहीं है, यूनियन पब्लिक सर्विस कमीशन के अधिकारी काम करते हैं। अगर ये प्रशासन चलाना सचमुच चाहते, साई रेड्डी साहब ने सही कहा, मैं उस शब्द का प्रयोग नहीं करूंगा, अगर ये सचमुच चलाना चाहते सभापति महोदय, तो इन्होंने 2014 में ही स्टेट पब्लिक सर्विस कमीशन बना लिया होता और अपने कर्मचारियों की नियुक्ति कर ली होती। सच क्या है महोदय? यह कानून स्टेट पब्लिक सर्विस कमीशन की स्थापना करता है, आर्टिकल 41 को जमीनी धरातल पर लागू करता है और लिखता है दिल्ली राजधानी राज्य क्षेत्र में समूह ख अराजपत्रित और समूह ग पदों पर नियुक्ति के लिए भर्ती अभिकरण दिल्ली अधीनस्थ सेवा चयन बोर्ड बनाया जाएगा। तो अध्यक्ष महोदय, सभापति महोदय, वास्तव में यह विधेयक दिल्ली सरकार को इंपावर करने वाला विधेयक है। मैं अब अपनी बातें खत्म करूंगा। आपने विपक्ष के नेता को सुना है, बड़े दिन बाद बहस हो रही है और अच्छी बहस हो रही है। थोड़ा देर हमको भी जैसे उन्हें बोलने दिया, मुझको भी बोलने दीजिए। अध्यक्ष महोदय, सभापति महोदय, ये लोग कोर्ट के निर्णय की बात कर रहे हैं। क्या है कोर्ट का निर्णय? पढ़ा है किसी ने? कोर्ट के निर्णय के 2 हिस्से मैं आपको पढ़ के सुनाना चाहूंगा। एक हिस्सा कहता है, ये लिखित निर्णय है मेरे पास, ये पूरी किताब है कोर्ट के निर्णय की, मैं शब्दों को साहित्य के आधार पर बोल रहा हूं। कोर्ट का निर्णय कहता है, द पार्लियामेंट हैज लेजिस्लेटिव कॉम्पिटेंस ओवर ऑल द मैटर्स इन द लिस्ट 2 एंड द लिस्ट 3 इन रिलेशन टू द NCTD, इंक्लूडिंग the entries which have been kept out of the legislative domain। बस मैं समाप्त कर रहा हूं। और अंतिम बात क्या कहा कोर्ट ने? ये लोग ले दही दे दही वाले हैं। प्लीज कैसे? अंतिम लाइन सबसे, आप तो विधि विशेषज्ञ हैं, आपसे अधिक कौन जानता है हुजूर? उन्होंने कहा, वी हैव आंसर्ड द इशू रेफर टू द कॉन्स्टिट्यूशन बेंच। हमको एक इशू रेफर किया गया है, हमने उसका जवाब दे दिया। बाई द ऑर्डर डेटेड 6 मई 2022, 6 मई 2022 को हमें एक इशू रेफर किया गया था, हमने उसका जवाब दे दिया। द रजिस्ट्री शैल प्लेस द पेपर ऑफ दिस अपील बिफोर द रेगुलर बेंच फॉर डिस्पोजल, यानी डिस्पोजल करने के लिए माननीय उच्च न्यायालय के इस निर्णय को आप जानते हैं सभापति महोदय, इसे रेगुलर बेंच में जाना था और वहां का निर्णय आना था, लेकिन यह रात में अधिकारियों के घर में घुसना, उनके यहाँ लाठी पोठी चलाना, अधिकारियों को मारना, सतर्कता विभाग के कागज निकालना। मैं खाली एक चीज जानना चाहता हूं, उन कागजों में था क्या जिसको ये निकाल के लाना चाहते? मैं धन्यवाद देता हूं इन लोगों को। अध्यक्ष महोदय, खुल चुकी है इनकी कलियत, जान चुके हैं दिल्ली के लोग। और आने दीजिए लोकसभा का चुनाव, ये 2 मिल गए हैं जो आपस में ना, ये हमको समझाना चाहते हैं आत्मा की आवाज। ये हम भाजपा के लोग हैं, सिद्धांत से जीते हैं, आपकी तरह अवसरवादी नहीं है कि कल एक दूसरे को गाली देते हैं। कितनी शर्मिंदगी होती है। नेहरू जी जब सुनते होंगे कि ये हमारे परनाती महोदय हमारी पार्टी को डुबा करके ही मानेंगे। मैं इसी के साथ अपनी बातों को समाप्त करता हूं।
डॉक्टर के केशव राव। नो सर, डॉक्टर के केशव राव, डॉक्टर के केशव राव, डॉक्टर के केशव राव, प्लीज।
Thank you, sir. I stand disadvantaged. Coming in the serial of some 8 or 9, whatever I had to talk has already been taken over by Mr. Sanghvi and also Sukhendu. So I don't want to repeat what exactly the Supreme Court has said, what the Supreme Court judgment has said, and how to analyze it, and to tell you that what you have done, we are not at crossroads, we are at crossroads. Please, you understand, I am taking this serious. I am taking it in new plank, sir, because I don't want to repeat whatever has been said by Sukhendu and also Mr. Singhvi. What they said is right. It is a fraud played on the Constitution, this ordinance, and it is absolutely with a mollified intention they have done. I understand your concern also, sir, because Sukhendu was talking that you had a sardonic smile on your face. It's only because I know this House has all the right to take any legislation it wants. That is your stand, has been the day you took over as the Vice Chairman. But at the same time, its limitations also have to be understood. So that is why I will not take a stand on that. But I will only tell my friend here that we are not discussing the CBI, or we are not talking about any criminal law here. We are talking about a constitutional law which is coming to replace the ordinance, which again is a statutory thing. When we oppose it, it is called statutory resolution. We don't oppose it because we are opposing in a debate. We oppose the bill here in the ordinance bill as statutory. I don't know why Congress was so much worried when our Sai Reddy was speaking. Everybody has these compulsions, and Sai Reddy's compulsions you will never understand. So please understand the compulsions of each one. As you said, everybody, the compulsions include many things. I don't want to go into them. So politically we take a stand. But anyhow, sir, we have... I am always with Constitution, sir, with this party or that party. I have resigned as a CWC member, I have resigned as Congress. Sir, Lok Sabha has discussed this in detail. And the debate yesterday was very informative and erudite. Because I am not trying to take what Mr. Singhvi or Sukhendu has said, I would like to take the entire debate to a different flag, which you will appreciate, sir. But before doing that, let me also quote what the Home Minister has said in the Lok Sabha yesterday. He was surprised how all of them came together when they were not together at all. He was worried about this grouping. Let me tell you, I am not part of India. I am udhar bol raha hu. I am not part of INDIA. But at the same time, when our nation is threatened, when there is a threat on the border, all of us join together to face the enemy. Like that, today I have an enemy in somebody who is trying to subvert Constitution. This subversion, I am against that. I stand against you because it is the Constitution that matters, not your politics. Unfortunately, the speeches that are being made, the debate that was involving itself into, was all about politics. One blaming the other. That is not the question. Today, right before you is something. And I would say, yesterday, while the debate was very good in the Lok Sabha, a suggestion, not a suggestion, a remark came from the one party, a recognized, known legal brain, Mr. Pinaki Mishra, who said he stood a very stout defense for you. He defended the ordinance, but at the same time he said, when it comes to the basic issue of the ordinance, when it comes to services, and when the Supreme Court sees the fit, I don't think we should rush through it, and we should wait for another few days. This is what exactly a constitutionalist should do. Sir, I am trying to tell you what my view is. Or Patra also agrees that it is not keeping the equidistance. It is appreciating the constitutional point.
Yes.
What Pinaki was saying yesterday was, Pinaki Mishra was saying yesterday was, we are not sure of what is happening, and the Supreme Court is absolutely against the particular bill. and hence let us wait before I possible. Sir, anyhow, sir, as I said, we all join together. The entire opposition is one when something serious of this nature happens. Sir, yesterday the Home Minister in the Lok Sabha, please, he was building a narrative. Not only he, his promulgated minister, one of the ministers of state, was building a narrative against the Kejriwal. It was not against AAP. They were taking the Kejriwal's names, Shahenshah, some Sheesh Mahal, or this, somebody, even here also. But if somebody is really corrupt, if you are building a narrative for corruption of a state, you have a right. You are Home Minister of the country. Instead of that, why are you meddling with the Constitution of India? You do that now. That is what we are waiting. That is what the members here said.
Please,
even if you are removing the state.
Dr. Keshav.
Even if you are removing the state.
Dr. Keshav.
Take up, sir.
Through me.
Yes, Dr. So,
I will reflect everything the other side.
Yeah, sir.
I am a good reflector.
So I don't know why Kejriwal should shake the BJP or the parliament so much. I never knew that he was that powerful man, that his corruption has made you pass constitutional amendment bills. Now, sir, one other point, because I am not getting into the integrities of the SC judgment, but one thing I tell you, what really surprises me, and it should have surprised you also, when a unanimous decision of 5 judges going along with the CJI sign a thing before the ink could dry, you have the pen of the president giving an ordinance. That too, it comes on the last day of the Supreme Court's working days. See, this really gives some kind of suspicion, and as a lawmakers, we get surprised over that kind of gestures. What we expect is, this is a house which discusses the law. If it is not good, we throw it out. If it is good, we opt it. Now, sir, as I have already said, it is a fraud, I will not say. Sir, why it is a fraud is, moreover, I will not again repeat, sir, more than 3 times the Supreme Court judgment said the representative character of a government is what is democracy is all about. And that cannot be replied. Sir, now, this representative form of government is a triple chain of command which he said. Again, I will not go into that because much has been said about it now. Sir, I want to take the entire plank on a different plan. I want to take a debate on the different plank. Now, the Home Minister is smiling because he thinks I have no points. I think I have more points than Singhvi has. But I don't want to waste the time of speaking. I have a problem. So, sir, I don't want to recollect or remind you of the Americans and the Supreme Court judgment. But when you read them together, in conjecture, you would understand what is exactly the constitutional morality is. I will not able. So without constitutional morality, dharma can never be established. Constitution is our dharma. So without morality, that cannot be established. Sir, where are we leading to by giving all these kind of things? Before that, I also have to wait, my papers. Sir, Mr. Smita, you said this is not about Delhi at all. What was referred to in the Supreme Court is about the cantors of NCTD and also about 239 AAA. What is cantors? It is about functioning. Cantors of 239 NA is nothing but the functioning. On that, the Supreme Court very clearly said, the further ordinance hands over the government Delhi to bureaucrats, and the ordinance hands over the governance of Delhi to its bureaucrats. This is what is happening. That takes me to my subject today, sir. Sir, I'm afraid we are opening a new era. It is a serious matter for the Home Minister to think, and also the minister, however they are floating. We are entering a new era of what is known as bureaucracy. I am not against bureaucrats. There is a subtle difference between a bureaucrat and a bureaucracy. Bureaucracy is when you make this single-minded thinking into a theory and a policy, it becomes bureaucracy. When you shun your accountability, it becomes bureaucracy. Now we are, by handing over every power to a bureaucrat, and like the chief minister, elected chief minister, elected government, then it becomes bureaucracy. Sir. I want Yadav to appreciate this point, because I'm afraid of this, because this has been discussed time and again in many of the books. Like, sir, even short Mill said, that man will be accepted if not anybody else. Mill referred to the bureaucracy as a distinct from government, separate from the representative democracy. So when you are thinking of representative government, which the verdict has stressed too many times, Karl Marx theorized about the role and function of bureaucracy in a critique of Hegel's philosophy. He said, you can depend on anything, but not on bureaucracy. Sir, I am afraid of one thing. Please understand. The students of history should understand. I am telling you, we have best of bureaucrats as people's representatives here. They are accountable to people. Those who are not accountable are called bureaucrats. In my reference here, those who are coming into this house, like we had one of the best bureaucrats, Mr. Manmohan Singh ji, who ruled this country. So I am not against bureaucrats, but this mindset that we should go to an agency which is not accountable to people and overrule who is accountable to people is what exactly is. Thank you, sir. Sir, I lost it. Sir, I am putting, but I will not take the names, but I have Mill and Wilson, Udo Wilson, and one answer to this problem is to say that bureaucracy has no place in all real democracy. Sir, time is over. So, yes, sir, you would appreciate, I would give a last sentence. Politics is an art of absurdities. You find them alarm. I am out of it. But you wrongly diagnose it and give a wrong remedy. That is what exactly is the thing. Let us think. This is, again, Marx, great American writer. So with this, I'll tell you, let us not, in our temptation, open the gates for a new agency to take over the representative character of this country, because we have seen, we have come long way from monarchy to autocracy to aristocracy to democracy and republic, and now the new word used by Supreme Court is representative government. So this is what I am telling you. So my answer is this is, we are at crossroads because we are trying to bury democracy, representative character, we are disregarding the representative character, and this bill has to be opposed by everybody who has some kind of a regard for democracy.
Dr. Keshav, I am grateful. You have taken to paper glass. Because he sought my permission to have a glass of water. I said, don't have steel, don't have glass, have only paper glass. Thank you. Message from Lok Sabha, Secretary General.
Sir, with your kind permission, I rise to report that the Lok Sabha at its sitting held on 7th August 2023 passed the Digital Personal Data Protection Bill 2023. I lay a copy of the said bill on the table.
Professor Manoj Kumar Jha, 9 minutes.
जी सर, वाकिफ हैं. शुक्रिया सर. बिल्कुल. शुक्रिया सभापति महोदय. एक छोटी कहानी से शुरू करना चाहता हूं. हमारे विश्वविद्यालय में एक शिक्षक थे, वो कह रहे थे कि एक सेठ थे राजस्थान में, अचानक सांप सांप चिल्लाने लगे. तो लोग आए, बोले क्या हुआ? बोला देखो सांप अभी पेट पर से चल के चला गया. बोले काटा तो नहीं ना? बोला नहीं काटा नहीं, रास्ता देख गया है. So when I rise
Professor,
today,
this is my court. Everyone in the house knows. नोट ऑफ योर यूनिवर्सिटी।
सर
ये तो मैंने कहा है।
Sir, I would want all of you to give me uninterrupted time. I'll not speak anything which is going to prick you or disturb your rhythm. What I wanted to say, sir, असल में कई वर्ष पूर्व भी देखा इस देश में, आज भी देख रहे हैं, जब बहुत बड़ी सत्ता आती है ना, तो कई ख्यालात आते हैं, कुछ अच्छे होते हैं और कुछ लगता है जिसको हम कहते हैं लोएस्ट हैंगिंग फ्रूट। मैं और मेरी कलीग, सीनियर कलीग जया जी, हम लोग बात कर रहे थे, इतने पावर का करोगे क्या? कम है क्या? इतने राज्यों में सरकार है, केंद्र में सरकार है, 303 का बहुमत है, उसके बावजूद अगर किसी निर्वाचित सरकार को लेकर के ये आपकी प्रणाली हो, कार्य प्रणाली हो, जहां की सुप्रीम को 11 मई को सुप्रीम कोर्ट का ऑब्जर्वेशन हुआ, मेरे कई कलीग कह चुके हैं, संभवतः हमारी सरकार ने सोचा होगा कि वेकेशन में जाने से पूर्व उनको कुछ ऐसा पकड़ा दो कि अवकाश में भी वो सोचते रहे इसके बारे में। तो उन्होंने 19 मई को ये ऑर्डिनेंस लेकर के आए। तो अब जजों का काम था कि इस पर लगातार सोचते रहे। सर, इससे पहले कि मोटा मोटी कुछ बिंदु पे मैं आऊं, मेरे कुछ साथी वो जिन्होंने लोकसभा में वोट किया है, मोस्ट लाइकली दे विल डू द सेम हियर। हालांकि लोकसभा के बारे में जिक्र नहीं करना चाहता था, माननीय सभापति महोदय, डाइवर्सिटी शब्द का आप बहुत जिक्र करते हैं, हम सब उसमें रिजॉइस करते हैं, हमारी प्राइड है वो। लेकिन एक मंत्री महोदया डाइवर्सिटी बोलते बोलते बोल गई कि इंडिया इज कॉम्प्लिकेटेड। सर, बचपन से लेकर आज तक इंडिया कॉम्प्लिकेटेड नहीं लगा कभी, ये रिकॉर्ड में है पार्लियामेंट के, इसलिए मेरी चिंता है। इंडिया कॉम्प्लिकेटेड नहीं है सर, बड़ा सहज स्वभाव है इंडिया का, महासागर वाला है सर, सब कुछ समा जाता है, मजहब हो, धर्म हो, जाति हो, कौम हो, कोई हो। लेकिन इसको जब तालाब बनाने की आप कोशिश करते हैं तो महासागर तालाब नहीं बनना चाहता। सब फॉर ऑल दोज फ्रेंड्स, बड़ी अच्छी अच्छी बात कही, इक्वी डिस्टेंस। सर, इक्वी डिस्टेंस का मतलब होता है न्यूट्रलिटी। जब चूहे की पूंछ पे हाथी का पांव पड़ा हो तो न्यूट्रलिटी, उस चूहे से पूछिए कि उसको कैसा लग रहा है। तो मैं समझता हूं, इसलिए सर एक शेर अर्ज किया है, आज बड़े शेर पढ़े गए हैं, सुधांशु जी ने पढ़ा, तो मैं भी एक अर्ज करता हूं सर। ये पड़ोस के मुल्क से आया है, तुम तकल्लुफ को भी इखलास समझते हो फराज, तुम तकल्लुफ को भी इखलास, इखलास मतलब ट्रू फ्रेंडशिप, तुम तकल्लुफ को भी इखलास समझते हो फराज। दोस्त होता नहीं है हर कोई हाथ मिलाने वाला, आपकी पेश नजर है जी। तो मैं ये कहना चाह रहा था सर, एट अ हिस्टोरिकल जंक्चर, एक चीज और मुझे बड़ी अच्छी लगी उस दिन, हमारे माननीय गृह मंत्री जी ने जवाहरलाल नेहरू जी को कोट किया। एक पल को मुझको लगा कि इस शांतिवन में अस्थियां कसमसा गई होंगी, ये हुआ क्या, ये हुआ क्या। फिर अंबेडकर साहब को भी कोट किया, राजा जी को कोट किया, उन्होंने कन्हैयालाल मानिकलाल मुंशी को कोट नहीं किया, एचवी कामत को कोट नहीं किया, जो शायद ज्यादा उनके पक्ष में तर्क आ जाता। सर, विश्वविद्यालय में मैं पढ़ाता हूं तो पीएचडी के स्टूडेंट्स को साइटेशन हम लोग सिखाते हैं, जिसको कहते हैं एथिकल साइटेशन। एथिकल साइटेशन में यह नहीं होता है कि सेमी कोलोन के बाद का ले लिया और शुरू वाला छोड़ दिया। उदाहरण के लिए कहता हूं कि आज तक इस दुनिया में सबको लगता है इस देश में कि मार्क्स ने कहा था कि धर्म अफीम है, रिलीजन इज द ओपियम फॉर मासेस। सॉरी सर, द एंटायर कोट इज religion is the sigh of the oppressed creature, the heart of a heartless world, and the soul of soulless condition. It is the opium of people. सर, अब इसमें क्या किया हमने, सिर्फ ओपियम वाला लाइन निकाल लिया और मार्क्स को कह दिया कि धर्म विरोधी था। सर, मैं इसलिए कहता हूं साइटेशन बहुत इंपॉर्टेंट चीज है। बहरहाल जवाहरलाल जी की अस्थियों को मजा आया होगा, जहां तक मुझको लगता है शांतिवन में। सर, ये मूलतः मैं इसलिए नहीं कहता कि मैं बीजेपी के कार्यप्रणाली का विरोधी हूं सर, वो एक पॉलिटिकल रियलिटी है, हम भी एक पॉलिटिकल रियलिटी हैं। हम शत्रुता की जुबान से हमें एक दूसरे को संबोधन नहीं करना चाहिए, न सदन में न सदन के बाहर। साहब, हम इंडियन मुजाहिदीन नहीं है साहब, हम ईस्ट इंडिया कंपनी नहीं है, हम वो भारतवर्ष हैं जिसको महासागर मैंने कहा, और उस महासागर में आप भी हैं, हम भी हैं। हम और आप एक दूसरे की कीमत पर नहीं है। तो सर, मैं ये कहना चाहता था कि ये प्रतिगामी बिल है। सर, आपको घंटी नहीं बजाना पड़ेगा, मैं प्रॉमिस करता हूं, पक्का उसी में खत्म कर दूंगा। सर, प्रतिगामी मैंने क्यों कहा? दुनिया देख रही है कि हम कितना प्रोग्रेसिव लेजिस्लेशन ला रहे हैं। सर, ये मुझे जो चिंता इसमें ये हो रही है कि माननीय सर्वोच्च न्यायालय ने एक निर्णय दिया। सर, कुछ सोच के दिया होगा ना। आप अक्सर कहते हैं कि नेहरू नहीं चाहते थे। अरे नेहरू 56 में नहीं चाहते थे, 67 वर्ष बीत गए हैं, हकीकत नहीं बदलती क्या? नेहरू के टाइम में हम सार्वजनिक क्षेत्रों में कितना ध्यान देते थे और आज हम बेचने पे ध्यान दे रहे हैं। ये फर्क आया है ना सर। चूंकि ये फर्क आया है तो हर हकीकत में फर्क होता है। 56 की दिल्ली और आज की दिल्ली वही नहीं है सर। सर, मैं तो अरविंद केजरीवाल जी का बिल ही नहीं मानता हूं, दिल्ली गवर्नमेंट का बिल ही नहीं मानता हूं। मैं तो ये मानता हूं कि सर, अगर ये प्रयोग सफल हुआ, अगर सांप ने रास्ता देख लिया, तो कल को उन पर भी गाज गिरेगी जो आज न्यूट्रलिटी और इक्विडिस्टेंट के नाम पर न जाने क्या क्या सोच रहे हैं। सर, हम तब भी आपके साथ होंगे, ये तो गारंटी है सर। हमारे पास कोई विकल्प ही नहीं है। परेशान हताश लोगों के पक्ष में खड़ा होना। हम तो कश्मीर चल रहा था, उस वक्त आम आदमी पार्टी ने कोई और पोजीशन लिया था। आज उनको समझ में आ रहा होगा कि क्यों उस वक्त वो पोजीशन लिया। और आज मैं ये कह रहा हूं कि कल को किसी राज्य के साथ होगा, हम आपके साथ होंगे। सर, सेपरेशन ऑफ पावर को लेकर के मेरे कई कलीग कह चुके हैं, मैं कुछ नहीं कहना चाहता, बस ये 3 चीज कहूंगा सर। अगर ब्यूरोक्रेट्स मिनिस्टर को उत्तरदायी नहीं है सर, ये अराजकता को जन्म नहीं देगी क्या? मैं दिल्ली की जनता, अगर मैं दिल्ली सरकार हूं, मैं दिल्ली की जनता के लिए उत्तरदायी हूं। जैसे राघव कह रहे थे, अगर कोई विसंगति कहीं आती है, एलजी साहब के पास जाऊं सर, वो चुनाव जीते। हालांकि मैं जानता हूं कि इस देश में गवर्नर्स और लेफ्टिनेंट गवर्नर्स की भूमिका में विस्तार हो गया, अब तो वो राज्यों के नाम बदल दे रहे हैं। सर, आपकी मुस्कुराहट इंगित कर रही है कुछ। मैं ये कहना चाह रहा था सर, और मैं समझता हूं कि ये बात मैं कह करके, और 239AA के बारे में जो बातें कही गई हैं, मैं उसको दोहराना नहीं चाहता। सिर्फ मैं एक चीज पे आऊंगा, कोरम। सर, ये कमाल का कोरम हुआ, 3 में से 2 होंगे। मुख्यमंत्री बेचारा चेयरमैन है, बहुत अच्छी बात कही उन्होंने, चेयरमैन विदाउट चेयर। मुख्यमंत्री चेयरमैन है, वो अगर 2 मिनट लेट भी पहुंचेंगे तो कोरम डिसाइड कर लेगा क्या करना है दिल्ली के लिए। सर, इट इज नॉट कोरम, it is actually an instrument to decimate the very idea of elected government. सर, सर घंटी हो जाइए। केशव राव जी की श्रेणी में 1.5-2 मिनट और ले लूंगा। सर, एक सोल डिस्क्रिशन का मामला आया है, सोल डिस्क्रिशन, और ये मैं आग्रह करूंगा माननीय गृह मंत्री जी से, हमारी महामहिम राष्ट्रपति के लिए भी जो संदर्भ आते हैं ना, to aid and advice of the cabinet or the ministry, सर, उनका भी सोल डिस्क्रिशन नहीं होता है। ये तो एक तरह से मुझे सोललेस डिस्क्रिशन दिख रहा है, आत्मा विहीन डिस्क्रिशन। सर, ये उसमें नहीं फिट बैठता है। सर, एक और चीज, मैं अभी कल गूगल कर रहा था सर, फेडरलिज्म पर 2 बहुत महत्वपूर्ण कोट मिले इंटरेस्टिंग लोगों के, एक चंद्रबाबू नायडू जी का, एक नवीन पटनायक जी का। वो कोट मैं पढ़ना नहीं चाहता हूं, बस मैं बता देना चाहता हूं। आखिरी सर, ये पेशे नजर तमाम लोगों के जो कहते हैं, अपील करते हैं कि साहब मदद करो इस बिल पे, तो दुष्यंत जी कह के गए थे कि उनकी अपील है कि हम उनकी मदद करें, चाकू की पसलियों से गुजारिश तो देखिए। सर, ये चाकू पसलियों से कह रही है हमारी मदद करो। सर, ये आसान मामला नहीं है। जय हिंद सर, जय हिंद।
Kareem.
Bigash is speaking, sir. Bigash, I was given the name. Bigash Bhattacharya. He is speaking for CPIM. CPI, for CPIM, Bigash Bhattacharya is speaking. I have given the name.
Bigash Bhattacharya. Bigash ji.
Chairman, sir.
7 minutes.
I will finish before that.
Yes.
The 7 minutes starts from here. Sir,
they end here.
We are all rational animal. Human is rational animal. The difference is rationality and animality. This rationality has driven us to move forward. The human civilization has advanced step by step.
we have never seen that the civilization has gone backwards. When the Constituent Assembly was discussing about the Constitution, you are well aware the role of governors were discussed. It was decided upon discussion the governor cannot be another source of power. Governors should act following the advice of the elected representatives and the representative of the government. This is a settled principle. And on the basis we have advanced to a people's government where the governor was an ornamental constitutional head to keep liaison with the center. The basic principle was that the federal principle and federal governance as per our constitution is carried forward. When the constitution was adopted, then Delhi was not a state. That was the union territory. Like many others, I am not going to give examples. That rationality has driven us to go forward and advance to the stage that the Delhi would be a state with certain restrictions. And the people will have the right of governance through their representative. This was the advancement of the Constitution. That's why the Constitution Amendment and 239 AA was incorporated. Now what we see, we find today that we are going backwards. The governor or the bureaucrats, they are bound by the constitutional principle and constitutional morality to be answerable to the elected representative. That is the republic. That's the republic, democratic republic, the constitution makes us thought of. No question of this party and that party. That was the result of independent struggle. I know some people did not have the legacy of independent struggle. They might have a different outlook, different thought. But this representative government is the outcome of independent struggle which the people fought, giving their lives, sacrificing lives, not surrendering their own right at the behest of the British mercy. Now this, and what this rule is, what this bill for? Bill is sought to replace the ordinance. Why the ordinance came for? Let us analyze stage by stage. I am not going to have a quarrel with this party or that party. The House is for discussion of the constitutionality of this bill. Nobody questions the power of Parliament. Having power is one thing, but exercise of power is wisdom. Unless you have the wisdom, the power gives you absolutely autocratic authority, which is against the basic principle of our constitution. Sir, have you noticed you were the governor and you felt that in spite of the best of your desire, you have to be bounded by the aid and advice of the government. That was your practically frustration, that without the aid and advice of the government, I cannot do anything. Because the constitution thought of, again I repeat, the representation of the people. People is the last word. They have chosen, might be XYZ to your liking or not liking. In the Delhi bill, have you seen? I have never seen. The Constitution of India, the Supreme Court had said, even the President of India doesn't have unguided discretion. And here, by a law, Parliament will say, you have a sole discretion. Would the Parliament invite the autocracy? This Indian Parliament, this law invites autocracy. This law speaks of throw away the people's government. I appoint a bureaucrat, I appoint somebody of my choice, he will dictate. You will be subservient to this. Have you gone through this bill? This bill would take us to completely the stage of animality, not the stage of advanced humanity for which we feel proud of. We, the people of India, we thought of governance. I was reading this bill. It reminded me the 1926 Act of Kolkata Corporation, where the executive was the superior. Mayor was just a subservient force. That was thrown away by the people. Now, here also, we have, under the Constitution, created third tier of government. Democracy means distribution of power. Democracy means not centralization of power. These bills only empowers a particular individual. He might be a wise man, but maximum power without any guidance would lead him to an autocrat. not less than the Hitlerite autocracy, which will take us to a doom. I have already submitted. Here, everybody has said, the chief minister is nothing but a puppet. Puppet of whom? The bureaucrats. Bureaucrats will dictate and chief ministers to follow. Is this the way you respect the constitutional principle and morality? Here the bill says, and in fact this bill is total amber written to the clauses, abdication of the governance by the people's representative. I would request all, don't be guided by your petty political feeling. This will lead to a situation, tomorrow I will say the Orissa government, Orissa chief minister has to be subservient to the governor, I pass rule. What would you do? The home minister's praise in the meeting would not give you result. They will say there is a precedent. Parliament has passed such a law. Lord, you have already given me a caution. I said I will finish within the time. I'll finish with the appeal to everybody, even to the Treasury bench. Don't be trapped with such a bill which ultimately will kill you. Don't make the democracy absolutely a farce. Let the representative government survive and the principle be extolled by the constitutional principles. With this, I appeal to you, reject this bill. I appeal to you to all, reject this bill.
Thank you. Very good. Shri Anil Prasad Hegde, 7 minutes. 1 second.
I'd like to say, there are a couple of references that have been made to Honorable Chief Minister Shri Naveen Patnaik ji. He is not a member of the House. So any remarks thereof may be kindly examined and discussed. One, sir. Sir, I'm not done. The second is a reference. The second, sir, I'm not yielding. I'm not yielding, sir. The second is with reference to the Odisha government, sir, as well. We are open to discussions on that. We can talk about 239 AA and why it only serves the Delhi government, because Delhi has a special place, is sui generis, which has been provided by Supreme Court. Therefore, to talk about any other government is not appropriate. The same may kindly be examined, sir.
I will examine and take a call.
Thank you.
Shri Anil Prasad Hegde, 7 minutes.
Thank you, Chairman.
7 minutes. 7 minutes.
Thank you, Chairman. I am rising on behalf of my party.
When there was a time for you to say so, Mr. Siva, you did not say so. And now you are saying so. I pleaded with everyone to say so. Mr. Hegde, 7 minutes. I'll take care of it.
Thank you, Chairman. I am rising on behalf of my party to strongly oppose this bill. At the outset, I want to make it clear that this bill, which seeks to ratify an ordinance, has dealt a severe blow to democracy and cooperative federalism. Sir, the union government is usurping the powers of the state by blatantly bulldozing through laws on subjects in state list. The government is also bartering the sovereignty of this country, sir. यह विधेयक दिल्ली का मुख्यमंत्री और 2 अधिकारियों को मिलाकर नेशनल कैपिटल सिविल सर्विसेज अथॉरिटी का स्थापना करेगा, जिसमें सिर्फ 2 लोगों का कोरम से इस अथॉरिटी का मीटिंग संभव है। इसका मतलब दिल्ली का चुनी हुई सरकार को काम करने, निर्णय लेने के लिए दिल्ली के लोगों ने जो अधिकार दिया है, इस अधिकार को 2 अधिकारी लोग एलजी का सहमति से छीन लेंगे। सर, ये कैसे अनडेमोक्रेटिक है? सर, पिछले सप्ताह इसी सत्र में बायोडायवर्सिटी एक्ट और फॉरेस्ट कंजर्वेशन एक्ट संशोधन बिल पास हुआ। ये बायोपायरेसी को बढ़ावा देगा। बायोडायवर्सिटी एक्ट में जेपीसी द्वारा किया गया 21 रिकमेंडेशंस में से 20 को दरकिनार करके पास किया गया है। सर, फॉरेस्ट कंजर्वेशन एक्ट is opening up precious forest resources to the exploitation of private companies, sir, to illustrate my point on sovereignty. Sir, पर्यावरण कानून उल्लंघन के लिए जो जुर्माना होता था, इसको समाप्त करने के लिए एक लंबे अरसे से अमेरिका को एनवायरमेंट प्रोटेक्शन एजेंसी और बहुराष्ट्रीय कंपनियों का मांग था। बिल पर ये बोल रहा हूं, जिसके बारे में मेरे पास प्रमाण है। पिछले सप्ताह यहां पर बायोडायवर्सिटी संशोधन बिल पास करके उन लोगों को उनका मांग को पूरा किया गया। सर ये दिल्ली के बारे में ही बोल रहा हूं। जब जैसे कैसे अनडेमोक्रेटिक है मैं बोल रहा हूं। विडंबना है यह है सर, पिछले 3 महीनों से मणिपुर में लगातार सामुदायिक हिंसा चल रहा है। इस संदर्भ में सर्वोच्च न्यायालय ने कॉन्स्टिट्यूशनल मशीनरी संपूर्ण ब्रेकडाउन बता रहा है। मणिपुर के मुख्यमंत्री को बदलने के बजाय दिल्ली में जहां पर सब कुछ ठीक है, यहां पर का कॉन्स्टिट्यूशनल मशीनरी में संशोधन लाना विडंबना है।
ऑनरेबल मेंबर,
बोलिए। मैंने बताया सर,
ऑनरेबल मेंबर,
स्टेट लिस्ट, स्टेट लिस्ट।
1 second. You are a senior person,
sir,
knowledgeable person,
sir.
You have to confine to the issue at hand.
I was talking how this is undemocratic. I was saying to drive home my point, that how the bill is undemocratic. I was giving an example, sir.
Confine.
मैंने बताया सर, ये बिल स्टेट लिस्ट में राज्य का अधिकार को छीना जा रहा है। सर, कृषि स्टेट लिस्ट में है सर। उदाहरण के लिए मेरे दल के मुख्यमंत्री नीतीश कुमार और दिल्ली के आम आदमी का सरकार जीएम मस्टर्ड और जीएम क्रॉप्स का विरोध किया है, जैव परिवर्तित फसल को। लेकिन पहली बार खाद्य क्षेत्र में जीएम फूड क्रॉप्स में दिल्ली यूनिवर्सिटी का DMH11 जीएम मस्टर्ड को 25 अक्टूबर 23 को केंद्र सरकार अप्रूवल दिया है। विदेशी कंपनियों को खाद्य क्षेत्र में जैव परिवर्तित फसलों को लाने के लिए दिल्ली यूनिवर्सिटी ट्रोजन हॉर्स बन के रास्ता साफ किया है सर।
Go ahead.
बोलो। सर,
चलो आगे चलो।
So 1 minute, सर, मैं जो आपको अभी सॉवरेनिटी के बारे में मैंने बताया, उसका एक मैंने आपको पढ़ के बताता हूँ एक लाइन। सर, ये यूएस का एनवायरमेंट प्रोटेक्शन एजेंसी का जो वहाँ का बराबर है, जो मिनिस्ट्री का बराबर है, ये बताता है कि this dialogue should be preceded by an analysis to be developed by EPA of India's current and relevant statutory provisions with a discussion of these interpretations and application in civil cases as well as specific recommended changes in the constitution. देश का संविधान में को बदलने के लिए अमेरिका हमको कह रहे हैं सर, और environmental statutes, regulation that are necessary to establish civil judicial authorities. Sir, मैं इस बिल को मेरे पार्टी विरोध करता है सर।
श्री जोश के मनी 4 minutes. 4 minutes.
Thank you, sir. I raise to oppose strongly the Government of National Capital Territory of Delhi Amendment Bill 2023. As said by my colleagues, it is anti-democratic, anti-federal, and it is aimed to distract the proper functioning of the democratically elected government of Delhi. When you talk about democracy, it is centered around the other people. It is made for the people. But this bill is formulated by the bureaucrats, of the bureaucrats, and for the union government. which means the people are eliminated and the essence of democracy is vanished. Yes. The bill is nothing short of a disgraceful attempt to snatch the power from the hands of the people. The way the ordinance was sneaked in without any valid justification is nothing short of the abuse of power. Very bad. What is the objective of this bill? What is the emergency of passing creating the ordinance? It is only a politically motive gain. The bill undermining the very essence of parliamentary democracy and the right of its citizen. It undermines the state's right and authority, turning Delhi into a mere puppet under the central government control. Yes, sir. The provision of the Honorable LG's sole discretion on matters recommended by the National Capital Civil Service Authority is a cruel joke on the concept of autonomy and self-governance. The bill is another betrayal of our democracy and federal system. So the bill is a systematic death blow to the democracy, is what achieved by this legislation. The central government, with the majority which they gained by decisive strategy, is now chopping the branch they sit. So we can cite a number of cases like, to establish this the various bill which is passed in the parliament, the multi-cooperative society bill, the agriculture bill, and also the intruding upon the sovereign domain of the state and so on. All these are trying to crush the federal system of our country. Exactly. The bill also adds to the list of actions undermining the federalism in the country. Basically, we understand that BJP is not able to get the power of the state of Delhi from the people of Delhi democratically, that is through election. Hence, they are trying to curb the powers of the state government. The only question is, if BJP was in power in Delhi, would they accept this bill? I am sure that they will never ever think of it. Let me conclude by saying this bill and the ordinance is an insult to the spirit of the nation. This legislation I will vehemently oppose until justice prevails. Thank you.
Shri Abdul Wahab, 4 minutes. Shri Abdul Wahab, not present. Shri P. Chidambaram, Shri P. Chidambaram, not present. Shri Mahesh Jethmalani,
Honorable Chairman, I rise to support this very, very important bill. I'm not in court and I'm surrounded by you.
Can I persuade you to yield in favor of Mr. Chidambaram?
Ah, yes, of course. I was actually supposed to speak after it.
No. Call has been taken by the chair. Shri P. Chidambaram.
I'm just looking for the time.
9 minutes, sir. There is a request from your party.
15 minutes. All right. Sir, my good friend Dr. Abhishek Singhvi has marshaled the legal arguments and placed the facts before this House. An appeal to them, appeal to the House and appeal to the Treasury benches not to proceed with this bill because this bill is unconstitutional. Now, I can understand the full-throated support given by the BJP, but what I do not understand is the half-hearted support extended by two of my learned friends, to my learned friends representing the BJD and the YSRCP. They know that this is unconstitutional. I think the Law Ministry knows it is unconstitutional. It's like a moth which burnt once when it approaches a fire, again approaches the same fire, and again approaches the same fire because it's a moth. Now, this government tried it once, it failed, it tried it a second. Government tried it once, it failed, it tried it a second time, it failed, and you're trying it a third time. I wish you what you will get, a spectacular failure when this bill is taken up. Be that as it may. I'm not getting into the legal arguments because we are not a court of law, nor, I'm sure, anyone in the chair wants to be a judge. We are the Council of States. We are duty-bound to protect the rights of states, rights of union territory. We are not representing an individual parliamentary constituency. I'm representing a state. Each one of my learned friends is representing a state. And collectively, we should represent all the states of India. What are we? Are we a union of states? Or are we going to become a union of moth-eaten states? Or a union of moth-eaten union territories? Or a union of municipalities? Please remember the old dictum, no taxation without representation. That's the fundamental premise of a representative and parliamentary democracy. Delhi has, according to the figures I sourced today, 3.17 crore people. Now, the 3.17 crore elect a government. They elect a government to govern them, to take decisions on their behalf. The underlying premise is we are a representative and parliamentary democracy. You may ask me, where are those words in the Constitution? Those words are in the Constitution. The magic words are that there shall be a council of ministers with the chief minister at its head to aid and advise the lieutenant governor. The words aid and advise is not some kind of a friendly advice. Aid and advise has a long constitutional history. Aid and advise means the real power is in the Council of Ministers. The LG exercises formal power. The real power is with the ministers of the government. The formal power is with the President of India. Aid and advise is magical words. What we are doing today is subverting the three magical words, aid and advice. Now, people are watching us. It's not only the 200-odd members in this House. People of Delhi are watching us. They will watch us today on television, on YouTube. They will know that this government is attempting to take away the real power of the elected representatives and put it in the hands of bureaucrats. Now, I asked in a tweet, and I'll ask this question. What is the merit you file with the bill? Leave alone the constitutional aspects. What is the merit you file? Is there merit in a three-member authority where two officers will constitute a majority and overrule the chief minister? Is there merit when 2 members of the 3 constitute a quorum, they can even call a meeting, hold a meeting without the Chief Minister? Is there merit that even if a decision is taken unanimously, the LG can overrule it? Is there merit that the member secretary, who is the principal secretary of Home, will convene a meeting with or without the Chief Minister? What is the merit? What is the merit? I heard you on television. I heard the honorable member on television. I didn't find you mention any merit in any clause of this bill. I heard you also. And I was even more disappointed. Therefore, what is the merit? What is the merit? What is the merit? What is the merit and what is the merit in this clause?
They are sitting in the opposition.
What is the merit in any clause? There is which clause has any merit in it?
I would urge the honourable member to get into a groove that
We are
does
not
not
getting into the
invite.
constitutionality. I'm saying, irrespective of the constitutionality, which clause has
Sir,
any
you went on a
merit in it?
tangent, physically and thoughtfully. Therefore, the honourable member had an occasion to be on his feet. I would urge you to confine to that limit.
Very well, this is my view.
It is expected of you, sir.
No, I have great respect for their view. All I'm saying is, I didn't find them point out the merit in the clause of the bill, irrespective of the Constitution. So we have a bill today, which the government thinks is the model for Delhi. They had invented a model for Jammu and Kashmir, and that is in court today. Please remember, we always talk about breakdown of the Constitution of India, breakdown of constitutional governance. Article 355, 356 speaks about breakdown of the constitutional machinery. What are we doing today? We are breaking the constitutional machinery. By passing this bill, by passing this bill, we are breaking the constitutional machinery as envisaged. We broke it on 5th of August 2019 in Kashmir, divided a state into 2 union territories, and sending a chill in the spines of every state that any state can be broken into union territories. What are we doing today? We are breaking the constitutional machinery. Sir,
honourable member,
let me end by saying, while I endorse whatever my good friend Dr. Singhvi said about the constitutionality, and there is another forum which will argue. Please remember, you have no constitutional authority to pass this bill, be that as it may. You have not even a moral authority to pass this bill. The treasury benches, when did they last win an election in Delhi? 15 years, Mrs. Sheila Dikshit was chief minister. I think there were 2 or 3 lieutenant governors.
Please
1 minute.
conclude.
2 or 3 lieutenant governors, and I was home minister for a while. Never once did the present present arrangement come in the way of Mrs. Sheila Dikshit functioning as perhaps one of the best chief ministers of this country.
Shri Mahesh Jethmalani.
Just one minute. I asked you before I started, you said 10 minutes, therefore I'm speaking. It's not 10 minutes yet.
It's 9 minutes.
It's 9 minutes. It's 9 minutes. You said if
Sir, my problem is that everyone needs support of Jairam.
When did the BJP last win an election? They won an election before 1998. 1998 to 15 years, Congress government was there. And after 2013, it's the AAP government. You won an election 25 years ago. What moral right have you to speak for the people of Delhi and say this is what the people of Delhi want? This is not what the people of Delhi want. This bill must be rejected.
Honorable Chairman, I rise to support this bill.
One second. Sir says it's getting louder. Decibel level has to be, is getting louder, sir. Yes, Mahesh Jethmalani.
Sir, Dr. Singhvi, in his opening remarks, said that he made a lot of uncharitable comments, that this was a bill, hunkar ka natija, his exact words. He also said that we were Alice in Wonderland, constitutional arrogance. All these words were used, but I found very little in his speech regarding the legality or the constitutionality of this bill. I am reminded about your Lordship, my Honourable Chairman. Very difficult to wear two hats on the same day. Honourable Chairman will recall, with all his eminence at the bar, there's an old saying,
You are the third senior advocate.
Yes.
I am listening for the day. And trust me, I will go home and read every word of each of you have said and privately get back to you.
It will be a deja vu moment for you. Anyways, we have an old saying in court that when a lawyer is strong on the law, he hammers the law. When he's strong on facts, he hammers the facts. When he's strong on neither, he hammers his opponents. A lot of that has happened today. Now, sir, I'll come to as Mr. Chidambaram has said that he'll not deal with the law in this matter. I don't blame him. For some time now, he's forgotten about law and compliance. So I don't blame him. Now, sir, let's come to the constitutionality of this bill. So the constitutionality of this bill is to be found in the Constitution itself. And that is 239AA. And I'll just read one provision. It may be a little pedantic for most people, but I'll just read. After all, sir, the Union Territory of Delhi is sui generis. The Supreme Court has said so in the 2023 May judgment. But when it said it was sui generis, which means unique, it meant that it was a sui generis Union Territory because it was the only Union Territory which had the privilege of having both a state legislature and a council of ministers. It is not a full-fledged state. That may be unfortunate. It is a sui generis, i.e. an escalated Union Territory with more powers than other Union Territories. Now, the provisions of the Constitution reflect that. If I may just read one article or one sub-article, 3B. Nothing in subclause A, which is the powers of the Union Territory of Delhi to legislate. It says, nothing in subclause A shall derogate, which means depart from, the powers of Parliament under this Constitution to make laws with respect to any matter for a Union Territory or any part thereof. Now, look, this is wide. Sir, this is wide. This is widespread. This is all-encompassing. It covers union list, state list, concurrent list. The union government can make powers, notwithstanding that there's a vacuum, on any matter in any of the three lists. So the ultimate power of the Union Territory of Delhi still vests, notwithstanding the fact that it's a sui generis Union Territory, ultimate power vests in the Union. That's point number one. Now, so what does the bill do? This really is a battle about control of services. It never arose in the past when Sheila Dikshit was the Chief Minister of Delhi, a reign which Mr. Chidambaram proudly flaunts. There was no question that she never thought that it was necessary to give Delhi full statehood in all the 10 years that she was in power. She never gave Delhi full statehood. Apart from that, she never thought it was necessary to have a provision like this because since times immemorial, and particularly since 1991, when Delhi got that sui generis status through 239, ever since it got there, it was almost accepted. It became a matter of convention that the powers of control over the services would vest in the union. And it did in fact happen. That was because the seat of government is New Delhi, of the union government. Parliament is here. Foreign diplomats are here. Embassies are here. So the seat of power being in Delhi, control over services in Delhi vested in the union government, and it passed muster over successive administrations. It was never questioned. Now, what does this bill do? This bill actually reflects the sui generis union territory status of Delhi. And I'll just read one provision. 45E is crucial. In the matter of transfer of postings, postings and transfer of the services, 45E creates a new body. It creates a body, an authority, known as the National Capital Civil Service Authority, to exercise powers conferred on and discharge the functions assigned to it under this part. Now, that body, the constitution of that body, reflects the sui generis nature of the Union Territory of Delhi, as also the fact that the ultimate control rests in the Union government. So, the authority referred to in subsection 1 shall consist of the following members, namely, the Chief Minister of the Government of National Capital of Delhi, who shall be the chairperson of the authority ex officio, and the other two members will be, so the Chief Minister of the Government of the National Capital Territory of Delhi is the ex officio chairman of the authority that will deal with postings and transfer. The Chief Secretary of the Government of National Capital Territory of Delhi member will be ex officio, and the Principal Home Secretary, Government of National Capital Territory of Delhi, will be the member secretary to the authority. So, the three-member authority will consist of the Chief Minister and two high-ranking bureaucrats from the center. This authority fully reflects the nature of the relationship between the Union Territory of Delhi and the Union government. This is reflective of that. Now, sir, what is the reason for this departure, if I may say so? This has been going on, as I said, since 1991. Control postings of services is within the jurisdiction of the Union government. I see none whatsoever. The only change of circumstances that seems to have taken place, if I may use an analogy from cricket, with the respective parties who are chiefly concerned with this change, AAP, Congress, and the BJP, is that the Congress, who never had any problem with this issue about control of services, has now, like a batsman who has lost form and hasn't scored a half century for 10 years, is now seeking an alliance so that it can inch towards its first 50. The AAP is like a cricket team whose captain has been caught ball tampering. A vigilance report exists, and suddenly they want to become vigilant about the vigilance report. The BJP's present government is the third umpire. We want to stop this nefarious practice. A convention, a wholesome convention for better administration and for effective administration of the Union Territory of Delhi by the Union government now needs to be made into law, lest people subvert the services and hide their corruption. I wholeheartedly and with all the vigor at my command support this. Thank you, Chairman.
Shri Abdul Wahab 4 minutes. 4 minutes.
Yeah, for me is more for me. Respected Chairman Saab and my colleagues are telling more about this Delhi bill. I don't have much to add to that one. My only wish is, this is only for 8 months business. Next government is of India. So everything what is happening here is negative. And Amit Shah ji thinking that he will be always the Home Minister only. You don't want to be Prime Minister also. So the next Prime Minister already announced, third term I am the Prime Minister. Modi ji was already told. So what is the need of this bill, thinking that I will be always Home Minister? So my request is to take this bill, and anyway it is going to be negated by the next government of us. It is for sure. Yes. So India will be ruling, all this will be null and void. So my request to Amit Shah ji, at this point of time, don't be in the history, don't be a villain instead of a hero. So what happened in Kashmir?
This word is not good.
Wedding is not, no,
Using a word villain.
Sorry, I am myself taking
you
back.
See, all of
I am
us.
withdrawing.
One second. All of us have to exemplify our conduct.
Yes.
So that it could be emulated by others.
Yes.
It is good of you.
I took back.
It is good of you to take snipe shots, but in the process, maintain decorum.
I didn't mean
and
that.
Dignity. Go ahead. It is expunged.
Yes.
Go ahead.
So, my request to Amit Shah ji, it is happened in Kashmir and in here and maybe in Punjab tomorrow, I don't know. So whatever is happening in, our immediate solution should be in Manipur and Haryana and other places. So I request Amit Shah ji to interfere in Manipur more than in Delhi affairs, small affairs. Some offices changing this and all. But this gentleman, our Chief Minister, came as a, what you call, I am telling, as a hero. I was thinking that they are the B team of BJP before I was thinking. But now only I came to know they are not the B team of BJP. They are also want to rule Delhi as a Chief Minister. So I stop this one asking again to Amit Shah ji to repeal this bill. Thank you.
Shri Ranjan Gogoi. Honorable members, it is the maiden speech of the honorable member.
I thank the Chairman, sir, for the opportunity. It's a great day, a maiden speech on a subject that is very dear to my heart, and a subject that can be as related to law as possible. So a maiden speech, I believe the chair is a little indulgent and gives a little more time, but I won't take much time. A maiden speech also has the protection of the House. It is freedom of speech in an absolute form. The member has a right to say on the first day whatever he wants. So, I would confine myself to the legality of the proposed legislation. And I will address the House and the Chair, of course, from three standpoints: sub judice, overreaching the Supreme Court's order, and the constitutional validity. So there is some faint voice about impropriety, sub judice. As a layman, it is not sub judice. What is pending before the Supreme Court is the validity of the ordinance. What the House is debating is on the validity of a law.
Please. Would you please take your seat? No. Absolutely no. 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 force me. The House was going well.
This is the replacement of that ordinance.
One second.
No, there is a difference.
All right. Do you want me to go further? Please take your seat.
Mr. Chairman,
I
sir.
will not allow. This is not good.
Mr.
No one
Chairman,
was
sir.
interrupted. You suddenly rise. The House is getting enlightened. Trust me. Mark every word. The House is getting enlightened. As was enlightened by others also. Please go ahead, sir.
Mr. Chairman, sir. What is pending before the Supreme Court is the validity of the ordinance and specifically two questions referred to the Constitution bench. That has nothing to do with what is being debated in the House, number one. Number two, this is for all the members of the House, and it has some importance so far as the relation between the judiciary and the executive is concerned. I would request all the members of the House to have a relook at Articles 105, 121, and 122. There is absolute freedom of speech in Parliament, and whatever a member says in Parliament cannot be questioned in a court of law. I do not find a similar constitutional provision restricting the debates in courts. What the courts cannot do under 121 is question the conduct of a judge in relation to a pending matter. The restriction that the House imposes on its own speech is self-imposed by the rules. And what do the rules provide? Mr. Chairman, sir, the rule says a member shall not discuss a matter of fact which is a court pending before a court of law. It's not a matter of fact that is what is being debated. It's a question of law. It is not even an interpretation of law. It's on a debate on law. Now, Mr. Chairman, sir, so where sub judice is concerned, the bill takes away 3A from the ordinance. To my mind, it's a perception, I may be wrong. To my mind, when 3A has been taken out of the ordinance and it is not there in the bill, the questions referred to the Constitution bench stands self-answered. Because if you read the order of the Supreme Court referring the matter to the Constitution bench, a copy of which I have got and I have read, my view is that the entire reference has been necessitated by the provision of 3A of the ordinance, which no longer exists. Therefore, it is the prerogative, the right of the members of the House to debate. The question of sub judice doesn't come. So far as overreaching or outreaching the order of the court, Supreme Court is concerned, very shortly put, the position in my perception is this. The state legislature makes laws for the states, the parliament makes laws for the union territories. For the National Capital Region of Delhi, which has a special status, the state legislature or the legislature of Delhi makes the laws on the state subjects, except 3. But as Mr. Jethmalani read out, by virtue of 239 3B, Parliament has a power to frame laws beyond these 3. And that is exactly what the bill is seeking to do. Therefore, there is no question of overreaching. And what has the Supreme Court repeatedly said? paragraph 164, two conclusions. These are the two conclusions. May I read out these two conclusions? The legislative 164C, the Legislative Assembly of the NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries. In addition to entries in List 1, in addition to entries in the Union List, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD. This is the conclusion in paragraph 164. C. Paragraph 164F. The executive power of the NCD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. So this is the conclusion of the Supreme Court. And therefore, now, what has the Supreme Court repeatedly held in the 2018 judgment and the 2023 judgment? Precisely this. And I'm very grateful for the fairness shown by the first speaker, Dr. Singhvi. If I'm not mistaken, what Dr. Singhvi said, the power of Parliament is not in dispute. He said it very fairly. The power of the legislative competence of Parliament is not in dispute. Then why would this law be bad? This law would be bad if it violates the fundamental rights, number one. Number two, if it violates any other provision of the Constitution, and if it violates the basic structure of the Constitution. Right.
Honorable members,
yes.
I don't have to remind honorable members, it's a maiden speech. Yes, please. And the honorable member is making his point very rationally.
Sir,
it is one point of view.
I will take.
Well, the chair has taken a call.
I will take 2 minutes.
And bear with it. Sorry.
You have 15 minutes. You have 15 minutes.
Should we?
So far as
One second.
Fundamental right is concerned.
Honorable member, one second.
Yes.
This House should not set an example that an honorable member with huge experience in his matter is making a point. And every time you rise and tell me, time is over. It is my authority on a maiden speech. Sorry. Honorable members, I have given adequate time to every member on the maiden speech.
Yes.
And I had every time pleaded with you to show respect. Merely because what the point is being made, it is required not to be registered, but to be digested. And you will have an opportunity to deal with it. We are getting input in this House from a very experienced legal mind. We got it from Dr. Singhvi. We got it from Mr. Chidambaram. We got it from Mr. Mahesh Jethmalani. We have to get also from Mr. Gagoi. Please, sir.
In any case, Honorable Chairman, sir, I have come to the end of it. Violation of fundamental rights. The only fundamental right that can be violated is perhaps Article 14, and that too, the limited part of Article 14, that the law is arbitrary. Is this law arbitrary? This doesn't appear to be so. The law may not be to my liking. That does not make it arbitrary.
Absolutely.
Next, does it violate the basic feature of the Constitution? Sir, I have to say something about the basic feature.
Please.
There's a book by Mr. Andarajuna,
Yes, yes.
the former Solicitor General, on the Keshavananda Bharti case.
Yes.
Having read the book, my view is that the doctrine of basic structure of the Constitution has a very debatable jurisprudential basis. I would not say anything more than this.
He does not suit the ruling party, sir, that is why.
I wouldn't say anything more. The doctrine of basic structure has a very debatable jurisprudential basis. In any case, Honorable Chairman, sir, what the bill provides is diluted form of what federalism, because it's a union territory, not a full-fledged state. Therefore, what you have is a diluted form, asymmetrical form of federalism. And the third thing is, does it violate any other part of the Constitution? The Supreme Court mentioned about triple autonomy. What you have under the bill is a modified form of triple autonomy. The bureaucrat is responsible to a lieutenant governor, who is responsible to the Home Ministry, who is responsible to the House. You have a modified form. If you want a full-fledged federalism, which today is a basic feature, though I have my own perceptions there, you can go for an amendment, for a constitutional amendment, and make Delhi a full-fledged state. Now, the most important thing, Chairman Sir, is Article 239AA, starting from 1 to 7, is not under challenge before the Supreme Court. Challenge it. That is not under challenge. Therefore, in my respectful submission, my contention, the bill is perfectly legitimately valid. But I fully support Mr. Vikas Bhattacharya, who has been a very close associate of mine. What is permissible need not necessarily be right. In the House today, parliamentary democracy compels members to vote according to party dictates. Fine, I cannot quarrel with that. It's a small section of people to whom you appeal to their conscience. To me, the bill is correct, right. My conscience tells me to do something, I'll do it. But if somebody disagrees, his conscience must be left free. Thank you. I am honored. I'm privileged.
Well, we have one thing in common. Dr. Vikas Bhattacharya is also my good friend and known to me for long. And I remember when he was mayor of Kolkata Municipal Corporation. Dr. Fozia Khan.
Thank you very much, sir. Sir, I wish to express my profound concerns and my vehement opposition to the bill, sir. This bill, as said by many of my colleagues, raises many constitutional apprehensions and threatens the very foundation of democratic principles and federal structure, sir. Sir, as already spoken by many, disrupting the triple chain of accountability jeopardizes the very essence of our democratic system and erodes the trust that the people repose in their elected representatives, sir. Sir, I think the most important in a democracy is the people. We must never forget that. Everything that we do here, everything that we do is only for the people. And if sir, we talk about people, my question is, can the electorate be betrayed? If you are betraying the electorate, isn't it a betrayal of democracy? When the people of Delhi have laid their trust on a particular government, couldn't we even have waited till the tenure to get over so that we wait legitimately for that government to finish the tenure till we make it toothless, sir? Why do we have to make a government toothless? It is here, sir, that we are laying a crack on democracy. On the timelines of history, sir, एक दिन आप भी नहीं रहेंगे, हम भी नहीं रहेंगे, हम और आप यहाँ के कोई नहीं रहेंगे, लेकिन सर जो डिसीजंस हम लेंगे वो डिसीजंस आगे के जनरेशंस के लिए यहाँ पर रहेंगे। सर, सुधांशु त्रिवेदी जी ने और बहुत सारे ट्रेजरी बेंचेस के सदस्यों ने वैयक्तिक टिप्पणी की है केजरीवाल जी पर। मैं ये पूछना चाहती हूँ सर कि अगर केजरीवाल जी से कोई गलती हो रही है ऐसा मान के भी चलते हैं तो क्या हमें कॉन्स्टिट्यूशनल अमेंडमेंट लाना चाहिए उसके लिए? मुझे ये बिल्कुल बात समझ में नहीं आती है सर। पार्लियामेंट डज हैव द पावर टू मेक लॉ। I agree with it, sir. We are not disputing that. But the essence of democracy cannot be killed at any cost, sir. And here we are killing the essence of democracy. Mr. Tiruchi Shiva here spoke about constitutional morality. And I more than agree with him, sir, that constitutional morality also must be considered when we are talking about this. And that if we agree that this is a union territory, why do we have an assembly at all? Let us dissolve this assembly and finish it and make a proper union territory. If it is a union territory, Delhi has a special status, sir. We must not forget that. And if you have a special status, although we have the right to make a law here, sir, we have to see that the essence of democracy is protected. Sir, here in this parliament, we speak about the nation. When a government... Sir, do I stop?
4 minutes. Go ahead. 1 minute more.
So if a government comes to... If it is elected, the government gains many things, sir. It gains decision-making, it gains power, पावर के साथ पुलिस है सर, पावर के साथ सीबीआई है, पावर के साथ ईडी है, पावर के साथ इनकम टैक्स डिपार्टमेंट है, पावर के साथ मीडिया है. लेकिन सर, it loses one thing. We must not forget that the government loses one thing when it comes to power, and that is, sir, whataboutery.
Oh, correct, sir.
Whataboutery is one thing that is the right and the duty of the opposition. But here what we see is, we are always talking about what about this. The moment the opposition says what about this, an answer comes from there, what about that? What about here? Somebody says what about there? Sir, this is not the right of the government here. It is the responsibility of the opposition. Thank you, sir.
Sri Sant. 4 minutes.
सिर्फ 4 minutes.
Only 4.
ऐसा कैसा चले? मेरा भी मिडन स्पीच है.
देखिए संजय जी, संजय जी, ये चीजें स्ट्रेंथ से डिटरमिन होती हैं, लंबे समय से हो रही
सर.
4 minutes.
सर, मैं इस बिल के लीगल एस्पेक्ट में नहीं जाना चाहता हूं. चिदम्बरम साहब, डॉक्टर सिंघवी, देश के पूर्व मुख्य न्यायाधीश, सभी ने इस बारे में बात किया है. लेकिन मैं इतना ही कहूंगा कि आप एक बहुत ही खतरनाक बिल लेकर आए और इस बिल को विरोध करने के लिए मैं खड़ा हूं.
जो इस बिल के समर्थन में वोट करेंगे वो भारत माता के साथ बेईमानी करेंगे, इंडिया के साथ बेईमानी करेंगे। ये देश का जो फेडरल स्ट्रक्चर है, ये फेडरल स्ट्रक्चर पर सीधा हमला है, लोकतंत्र की हत्या है। देखो 4 मिनट है, मुझे 2 मिनट काफी है, तो ज्यादा आवाज मत वहां से करिए। एक चुनी हुई सरकार दिल्ली में है, विधानसभा है, असेंबली है, सरकार, लोगों ने दिल्ली के चीफ सेक्रेटरी को वोट नहीं दिए हैं, एलजी को वोट नहीं दिया है, एलजी नहीं जाता वोट मांगने को, वोट मांगता है केजरीवाल या कोई मुख्यमंत्री या कोई सरकार, कोई नेता। हाँ, आप 5 बार चुनाव हार गए, 6 बार चुनाव हार गए। आज भी दिल्ली के विधानसभा में आपके 5 विधायक नहीं है, और इसलिए आप दिल्ली विधानसभा हो, चाहे महाराष्ट्र हो, चाहे पश्चिम बंगाल हो, चाहे तमिलनाडु हो, आप कब्जा लेने चाहते हैं। सरकारें कौन चलाएगा? हम लोकतंत्र की बात अगर करेंगे, मैं वहां की बहुत से लोगों के मेरे मित्र हैं, भाषण सुन रहा था, मुझे लगा उनको पुरानी चीज याद आएगी, जब लोकतंत्र के बारे में बड़ी-बड़ी बातें आप कर रहे थे, लेकिन आपकी आंखों में मुझे कोई लज्जा नहीं दिखी। मुझे 2 पंक्तियां याद आई गोपाल दास नीरज की, मत पूछो कि इस दौर में क्या क्या नहीं बिका। आपने तो सब कुछ बिक दिया है, पब्लिक सेक्टर से लेकर लोकतंत्र तक, विधायक, सांसद, सरकारें। मत पूछो कि इस दौर में क्या क्या नहीं बिका, आपके आंखों की शर्म तक आपने बेची है। सर, आप दिल्ली का चुनाव हार गए, आप 2024 का चुनाव भी हारने जा रहे हैं। इंडिया जीतेगा, इंडिया जीतेगा। प्रधानमंत्री, हाँ, प्रधानमंत्री जी का, प्रधानमंत्री विश्व गुरु बना दिया है, लेकिन उनका जो सम्मान होता है, उनको जो लोग बाइडेन से लेकर फ्रांस के प्रेसिडेंट तक जो गले लगाते हैं, वो नरेंद्र मोदी जी को नहीं गले लगाते, एक महान लोकतंत्र वाले देश के प्रधानमंत्री को गले लगाते हैं, इंडिया के प्रधानमंत्री को गले लगाते हैं। और आप उस महान परंपरा को, उस महान संस्कृति को आप खत्म करने जा रहे हैं। अभी प्रधानमंत्री पुणे में गए थे, लोकमान्य तिलक का नाम से उनको सबसे बड़ा अवार्ड मिला।
I requested the honorable members, and this is not a good tendency.
सर, मैंने क्या बोला?
No,
मैंने गलत क्या बोला?
One second. It is
प्रधानमंत्री जी
Mr. Sanjay Raut, it is not that
के नाम से पुरस्कार मिला।
Okay, your time is over.
लोकमान्य तिलक का
No, Mr. Your time is over, Sanjay Raut, and when I say your time is over, I mean time for this address only.
मेरा और 2 मिनट।
दिग्विजय सिंह जी, आप इतने सीनियर आदमी हैं।
सर, मेरा और 2 मिनट बाकी।
In this house, we must have respect for constitutional functionaries. Let us not create a system which is not good.
नहीं।
No. Priyanka. Message from Lok Sabha Secretary General. Message from Lok Sabha Secretary General.
Sir, with your kind permission, I rise to report that the Lok Sabha at its sitting held on 7th August 2023 passed 1. The Anusandhan National Research Foundation Bill 2023 and 2. The Pharmacy Amendment Bill 2023. I lay a copy each of the said bills on the table.
Shri Ghanshyam Tiwari, 15 minutes.
आदरणीय सभापति महोदय, मैं आपके माध्यम से
आज इसकी बहस की शुरुआत करते समय माननीय श्री अभिषेक मनु सिंघवी जी थे, उन्होंने चेतावनी दी बीजेडी को, YSR कांग्रेस को। उन्होंने कहा कि भाई आप इनके साथ जा रहे हैं तो आपके साथ अच्छा नहीं होगा, क्योंकि आग दूर तक आएगी। लेकिन सभापति महोदय, वो मेरे मित्र हैं, जोधपुर के हैं, मैं उनको याद दिलाना चाहता हूं कि वो केजरीवाल जी के पास वो गए हैं, इसलिए वो अपने आप को संभालें, क्योंकि केजरीवाल साहब के साथ जितने भी लोग थे जो शुरू में उनके साथ आए, चाहे प्रशांत भूषण जी आए, चाहे स्वर्गीय शांति भूषण जी आए, चाहे योगेंद्र यादव जी आए, चाहे कवि जी आए, या जितने भी लोग आए, वो सबसे पहले अन्ना हजारे आए। अन्ना हजारे की बात उन्होंने नहीं मानी, फिर किरण बेदी की बात उन्होंने नहीं मानी, फिर प्रशांत भूषण की बात उन्होंने नहीं मानी, फिर शांति भूषण जी की बात उन्होंने नहीं मानी, योगेंद्र यादव जी की बात नहीं मानी। सबको उन्होंने अलग अलग अपने स्थान पर भेज दिया। अब उसके बाद में 2 आदमी बच गए उनके पास में, वो श्री मनोज सिसोदिया जी बचे और सत्येंद्र जैन जी बचे। जब वो नहीं गए तो उन दोनों को जेल में भेज दिया। इस प्रकार से उनके पास फिर कोई नहीं रहा, क्या कोई नहीं रहा। इसलिए अब अगर कोई खतरा है तो खतरा कांग्रेस पार्टी को है, और कांग्रेस पार्टी उनसे सावधान रहे। और जहां तक ये कांग्रेस पार्टी का और आप पार्टी का साथ आने का सवाल है, सभापति महोदय, ये तो मुद्दा मैरिज है, ये तो कॉन्ट्रैक्ट हुआ था कि हमारा इस बिल में आप समर्थन करोगे तो हम आपके साथ आएंगे, और ये बिल लोकसभा में पास हो गया, अब ये राज्यसभा में पास होने वाला है। इसके बाद में ये मुद्दा मैरिज टूट जाएगी और ये केजरीवाल जी कांग्रेस के लिए सनीसर बनकर उनके सामने ही खड़े हो जाएंगे। इसलिए YSR कांग्रेस को या बीजू जनता दल को करने के बजाय कांग्रेस पार्टी स्वयं सोच ले कि उसका क्या हाल होने वाला है। दूसरी बात मैं करना चाहता हूं सभापति महोदय, उन्होंने बार बार एक बात कही कि साहब नेहरू जी के समय बात हुई, ये बात हुई। मैं सबको याद दिलाना चाहता हूं कि माननीय गृह मंत्री जो अमित शाह जी हमारे हैं, उनकी एक आदत है, वो लंबे समय से जो काम चल के आता है और जो पूरा नहीं होता, विवाद में रहता है, उसको पूरा कर देते हैं। जैसे आर्टिकल 370 नेहरू जी के समय से चलाया था, पूरा नहीं हुआ, इन्हीं सदनों में पास करके उन्होंने पारित कर दिया, वो पारित कराया, यस कराया सक्सेसफुली। और दूसरा, फिर इसी प्रकार से रामलला के, राम जी के मंदिर के बारे में बोल रहे थे, वो भी इनके गृह मंत्री के काल में पूरा हुआ। और ये विवाद जो पंडित जवाहर, ये विवाद जो पंडित जवाहरलाल नेहरू के समय से चला रहा था दिल्ली के बारे में, फेजल कमेटी बन रही है और डॉक्टर पट्टाभी सीतारामैया की कमेटी बन रही है, बाल कृष्ण की कमेटी बन रही है, और कई प्रकार से नगर परिषद बन रही है, नगर निगम बन रही है, मेट्रोपॉलिटन काउंसिल बन रही है। ये सारा काम करने के बाद में 15 वर्ष तक आदरणीय शीला दीक्षित जी के मुख्यमंत्री रहने के बाद, मदन लाल जी खुराना के रहने के बाद कोई विवाद नहीं हुआ। ये विवाद जब केजरीवाल जी आए, उन्होंने खड़ा किया। अब उस विवाद का भी समाधान आज माननीय अमित शाह जी के हाथ से हो जाएगा, और इस बार दिल्ली के बारे में कोई समाधान नहीं होगा। माननीय सभापति महोदय, मैं कहना चाहता हूँ, दूसरी बात जो यहाँ पर बार बार उठाई गई, मैं उससे सैद्धांतिक रूप से मतभेद रखता हूँ। माननीय गोगोई साहब यहाँ पर बैठे हैं, वो भी सुनेंगे, बड़े बड़े वकीलों की बात भी हमने सुनी है। कौन सा फैसला है जो सुप्रीम कोर्ट करता है? फैसला नेता करते हैं, पार्लियामेंटेरियंस करते हैं और संसद सदस्य करते हैं। मैं उदाहरण देकर कहना चाहता हूं, सबसे पहले तो मैं उदाहरण देना चाहता हूं कि पहला संविधान संशोधन कब आया। पहला संविधान संशोधन इस सदन में आया जब 1951 में सुप्रीम कोर्ट ने SC और ST के रिजर्वेशन को स्ट्रेट डाउन कर दिया। उसके बाद पहला संविधान संशोधन आया, और उसका निर्णय सुप्रीम कोर्ट ने नहीं किया, उसका निर्णय जनप्रतिनिधियों ने किया, और SC और ST को हमने रिजर्वेशन दिया। दूसरा बहुत बड़ा प्रसंग आया माननीय सभापति महोदय, कांग्रेस वाले सब भूल गए, संविधान, लोकतंत्र की हत्या हो रही है। आप भूल गए जब साहबानों का केस आया था सुप्रीम कोर्ट में, कर सुप्रीम कोर्ट ने फैसला किया था।
Honorable members, please keep silence. Please keep silence. Please.
जब साहबानों का केस आया था और सुप्रीम कोर्ट ने फैसला किया था कि एक महिला को गुजारा भत्ता मिलना चाहिए, उस समय कांग्रेस पार्टी को साफ सूख गया था। वो इसी सदन में संशोधन लेकर आई और संविधान के उन्होंने सुप्रीम कोर्ट के फैसले को पलटा। जो साहबानों के केस में पेश पलट सकते हैं वो आज संसदीय लोकतंत्र की दुहाई दे रहे हैं। इसके बाद माननीय सभापति महोदय और कितने प्रसंग आए। ओबीसी के आरक्षण का प्रसंग आया, ओबीसी के शिक्षा में रिजर्वेशन का प्रसंग आया और 9 सदस्यीय बेंच ने ईडब्ल्यूएस के आरक्षण को निरस्त कर दिया था। लेकिन माननीय नरेंद्र मोदी जी ने इसी सदन में संविधान संशोधन करके ईडब्ल्यूएस को आरक्षण दिलाया और 53 याचिकाओं को सुप्रीम कोर्ट ने बाद में निरस्त किया। इसलिए यह कहना कि यह संविधान की अवहेलना है, यह संविधान की अवहेलना भी नहीं है और यह लोकतंत्र की अवहेलना भी नहीं। दूसरी बात मैं कहना चाहता हूं, बार बार एक बात, इतनी जल्दी क्या हो गई थी, इतनी जल्दी क्या हो गई थी? भाई इतनी जल्दी सरकार को पूछ रहे हो तो यहाँ की सरकार को पूछो, दिल्ली को, उनको इतनी जल्दी क्या हो गई थी कि सुप्रीम कोर्ट का फैसला आते ही रात को 12 बजे जाकर ताले तोड़ने लगे। वो जल्दी कहां से आ गई थी? सब ये क्यों गई थी? तो ये इसलिए हुई। दूसरी बात, आज तक कोई भी दिल्ली की सरकार कोर्ट में नहीं गई। आदरणीय शीला दीक्षित जी भी नहीं गए, मदन लाल खुराना भी नहीं गए। ये किस लिए गए कोर्ट में, हाई कोर्ट में, कि हमको ये अधिकार मिलने चाहिए? ये अधिकार उसके पहले इनके पास नहीं थे तो ये गए, और गए तो दिल्ली हाई कोर्ट ने इनके खिलाफ फैसला किया। जब ये कोर्ट के इतने ही भक्त हैं तो फिर दिल्ली हाई कोर्ट का फैसला मान लेते, तो दिल्ली हाई कोर्ट का फैसला भी नहीं माना। इसके बाद में ये गए सुप्रीम कोर्ट में, और सुप्रीम कोर्ट में क्या हुआ? सुप्रीम कोर्ट का जो फैसला है उसका केवल एक आख्यान पढ़ते हैं, बाकी 2 आख्यान जो भी माननीय महेश जी ने भी बताए और माननीय गोगोई जी ने भी बताए, उनको पढ़ नहीं रहे। तो मीठा मीठा गप और कड़वा कड़वा थू। और ये जो आया है आज, ये जो संविधान संशोधन का बिल आया है, ये ऑर्डिनेंस को जो वो करने का बिल आया है, ये सुप्रीम कोर्ट की इच्छा के अनुसार आया है। और लेकिन किसी भी देश में सब जनप्रतिनिधि फैसला करते हैं। 1926 के पहले ब्रिटेन में महिलाओं को वोट का अधिकार नहीं था और वहां की प्रिवी काउंसिल ने तय कर दिया था कि अधिकार उनको नहीं मिल सकता क्योंकि कानून के अंतर्गत नहीं है। प्रिवी काउंसिल ने फैसला किया और फैसला करने के बाद में ब्रिटेन में महिलाओं को वोट का अधिकार मिला। भारत में तो पहले से है। ये जितने निग्रो हैं इनको वोट का अधिकार अमेरिका में नहीं था, और अमेरिका की ब्लैक इन ब्लैक को अधिकार नहीं था, और इनको जब वहां की फेडरल कोर्ट ने मना कर दिया कि आपको अधिकार नहीं मिलेगा, आप वोट नहीं दे सकते, कानून में नहीं है, तो अमेरिकन कांग्रेस ने प्रस्ताव पास कर उनको वोट का अधिकार दिया। उसी प्रकार दक्षिण अफ्रीका में हुआ, उसी प्रकार अन्य देशों में हुआ। इसलिए कोई सुप्रीम कोर्ट फैसला करेगा कि ये ठीक है कि ये गलत है, वो नहीं है। भारत में भी आज तक के 50 उदाहरण हैं जिनमें सुप्रीम कोर्ट के फैसलों को बदलकर हमने जनहित में निर्णय किए गए हैं, और ये दिल्ली के जनता के हित में सबसे बड़ा निर्णय माननीय अमित शाह जी लेकर आए हैं, वो हम करने जा रहे हैं। और इसलिए सभापति महोदय, मैं कहना चाहूंगा कि ये बार बार कहना कि दिल्ली के साथ अन्याय हो रहा है, दिल्ली का एक विशेष स्टेटस है, उस स्टेटस को सबने माना है। अब दिल्ली भारत की राजधानी है। एक भी दुनिया के किसी देश का उदाहरण आप नहीं दे सकते कि उस देश के अंदर वहां की राजधानी है, उसका अलग प्रांत हो। यहां पर विदेशी आते हैं, यहां पर इतने बड़े सम्मेलन होते हैं, और यहां पर भारत सरकार कितने काम कर रही था। अभी भारत मंडपम इतना बड़ा माननीय प्रधानमंत्री जी ने उद्घाटन किया है, वो केंद्र सरकार ने किया है। अब युगे युगेन भारत है, इतना बड़ा जो म्यूजियम बनने वाला है वो म्यूजियम भारत सरकार ही तो बना रही। तो ये इस प्रकार के काम दिल्ली में होना, दिल्ली में वार मेमोरियल बनना, दिल्ली में सारा काम होना, दिल्ली में सभी राजदूतों की सुरक्षा करना, अंतर्राष्ट्रीय सम्मेलन होना, ये सब काम हो रहे हैं। और इसलिए मैं निवेदन करना चाहता हूं कि ये बिल की 3 बातें जो कही गई, न तो ये संविधान के विपरीत है, न ये लोकतंत्र के विपरीत है, न ये दिल्ली की जनता के विपरीत है। हाँ, ये विपरीत है कांग्रेस पार्टी के संदीप दीक्षित, जो कांग्रेस पार्टी के खास आदमी नेता है कांग्रेस के, उन्होंने दिया स्टेटमेंट कि ये बिल ठीक है। पंजाब के कांग्रेस वालों ने कहा बिल ठीक है, लेकिन ये जो टेम्परेरी मुद्दा मेरी हुई थी, केजरीवाल जी ने कहा कि हमारा अगर समर्थन करोगे तो हम इंडिया में आएंगे, और आज ये जो पास होगा ये मुद्दा मेरी टूट जाएगी और वो इंडिया INDIA जो है उससे ए अलग खत्म हो जाएगा और ये 4 ही बचेंगे। क्योंकि पहला काम ये करेंगे तो उनके खिलाफ ही करेंगे। उदाहरण के लिए दिल्ली में पहले इनको मेजोरिटी नहीं मिली थी और कांग्रेस ने समर्थन देकर केजरीवाल जी को बढ़ा दिया था, बन गए। पर दूसरी बार जब आए तो कांग्रेस को पूरी को हजम कर गए, तो कांग्रेस साफ हो गई। इसी प्रकार पंजाब में कांग्रेस को साफ किया। अब आगे भी उनका उद्देश्य तो कांग्रेस को साफ करना है, तो हमारी कहां लड़ाई है। तो ये जो काम है, और इस प्रकार से मैं कहना चाहूंगा कि जितना सारा काम ये माननीय अमित शाह जी ने किया है और जो प्रस्ताव पेश किया है वो सब बातों को सोचकर किया है। और एक विवाद जो इतने लंबे समय से चल रहा था, फेजल कमेटी बने, डॉक्टर पट्टाभी सीतारमैया की बने, सरकारिया कमीशन बने, फिर संशोधन आया और 91 से लेकर 15 तक किसी प्रकार का विवाद नहीं हुआ। तो बोलने वालों को तो ये सोचना चाहिए था कि विवाद पैदा क्यों हुआ है। अब दूसरी बात, अगर ये संविधान के विपरीत होता तो इनको सुप्रीम कोर्ट में स्टे मिलता, वो स्टे भी नहीं मिला। ये वहां स्टे लेने गए, स्टे नहीं मिला। अब संविधान पीठ में गए तो संविधान पीठ इसको देखेगी। पहले ही फैसला कर दिया उन्होंने कि 339A के अंतर्गत सारे कानून बनाने का अधिकार भारत की संविधान सभा को है, वो है। दूसरी बात मैं कहना चाहूंगा कि ये धमकी देना दूसरे को, और एक बात मैं साफ रूप से कहना चाहूंगा, माननीय चिदम्बरम जी ने एक बात कही कि जम्मू और कश्मीर को उन्होंने 2 हिस्सों में बांट दिया। मैं कई बार कहता हूं कि लोग अपने कृत्यों को भूल जाते हैं। आंध्र प्रदेश से, तमिलनाडु से आंध्र प्रदेश अलग हुआ, कांग्रेस ने किया। फिर तेलंगाना और आंध्र अलग हुआ, कांग्रेस ने किया। कितने प्रांत कांग्रेस ने किया और कांग्रेस ने तोड़े। तो क्या कांग्रेस ने राज्यों के अधिकार खत्म कर दिए थे? प्लीज, वो कांग्रेस ने तोड़े। तो ये अधिकार केंद्र के पास। तो इस प्रकार पंजाब का विभाजन हुआ कांग्रेस के समय, हरियाणा बना, पंजाब बना, कांगड़ा मिलकर हिमाचल प्रदेश बना, ये कांग्रेस टाइम में। और संविधान की बात करते हैं और ये कहते हैं संशोधन क्यों लेकर आए। इलाहाबाद हाई कोर्ट के फैसले के बाद और जस्टिस AK कृष्णा अय्यर के सुप्रीम कोर्ट में स्टे न देने के पश्चात श्रीमती इंदिरा गांधी ने संविधान संशोधन करके अध्यादेश जारी करके अपनी मेंबरशिप कायम रखी। उतना बड़ा गलत काम हिंदुस्तान के इतिहास में आज तक नहीं हुआ। वो पार्टी पार्लियामेंट की बात करे, वो पार्टी कानून की बात करे, वो पार्टी संविधान की बात करे, तो मैं समझता हूं कि इससे बड़ा कोई धोखा नहीं हो सकता। इसलिए मैं कहना चाहता हूं कि ये कानून, ये अध्यादेश संविधान के अनुसार है, दिल्ली के जनता के हित में है और ये उसी प्रकार से समस्या का समाधान कर देगा जिस प्रकार से आर्टिकल 370 को समाप्त करके कश्मीर की समस्या का समाधान हुआ। अब किसी को भी कमेटी बनाने की जरूरत नहीं पड़ेगी, दिल्ली की समस्या का भी परमानेंट समाधान हो जाएगा। ये इस बिल में है। सभापति महोदय, आपने मुझे समय दिया, इसके लिए बहुत बहुत धन्यवाद।
धन्यवाद माननीय घनश्याम जी। ऑनरेबल श्री वाइको जी, you have 4 minutes, sir.
Mr. Deputy Chairman, sir, I crave your indulgence for some generosity we small parties always face the same difficulty. So I kindly be liberal with 1 or 2 minutes.
Honorable Chairman has been very generous. This debate is for 6 hours. You are getting 4 minutes. That's enough.
That's why he's asking.
Honorable, please. Honorable Vaikoji.
With all the force under my command, I oppose this abominable, undemocratic bill which strikes at the very root of democracy, the very root of federal spirit, at the very root of secularism, at the very root of social justice. Sir, the Government of National Capital Territory of Delhi Bill 2023 has brought forth seismic shifts in the governance landscape of Delhi. While cloaked in the garb of administrative efficacy, the bill in many ways appears to erode the democratic fabric that is intrinsic to Indian polity. The bill notably clips the wings of the Delhi Legislative Assembly by stripping it of the power to legislate on services. This is a deviation from the norm, where a state legislature would typically have jurisdiction over subjects in the state list with exceptions. The establishment of the National Capital Civil Services Authority on the surface may seem like an earnest attempt to streamline administrative processes. However, delving into composition and powers exposes an unsettling reality. The Chief Minister, an elected representative, is rendered virtually, I should not use the word impotent, so he is rendered puppet within the authority. Now I recall what I read in history when I studied the college about the triumvirate in Rome, which was called a democracy. In Rome, when Julius Caesar but kept his sword. After his assassination, another triumvirate was formed and Antony took the reins of the power. Here, directly opposite what is going to happen in India. Among the triumvirate, these two principal secretary and cabinet secretary, they are the majority, and the chief minister only a puppet. So this is the verdict given by the people of Delhi has been thrown into the dustbin of history. Many governors are appointed by the government, the central government. The governors in the opposite ruled states, how they behave, how... Please, I am coming to the end, sir. Sir, these governors, what they do in my state, Tamil Nadu, the governor has not given assent to the...
Please speak on Delhi.
Has not given assent to the bills sent by the State Assembly.
For all I am telling, please.
State Assembly. Please. So the Home Minister is sitting here. So he is the custodian of these governors. So these governors, what they do,
You are very senior member. We are discussing this Delhi bill. Please.
They do follow the philosophy of Hindutva and Sanatana Dharma. This is happening in my state, sir.
Please.
In my state. So the governors are behaving the agents of the central government.
No, it will not go on record. Yes. Please follow rule number 0 and 240. No. Please speak on the bill. Speak on the bill.
Of the central government.
Speak on the bill. Your time is over. Your time is over, sir. You please finish. Conclude. Time is over.
Finish. This bill should
already
be thrown out of history. Thrown
please.
Out of the...
Thank you.
Into the dustbin.
Thank you, Honorable Vaikoji. Thank you. Thank you. Mani Hardeep Singh Puri ji. Mani Hardeep Singh Puri.
Honorable Deputy Chairman, sir, one of the advantages of speaking so late into the discussion is that some of the most amazing statements bordering on the outlandish have already been responded to by others, and some of the facts will, I'm sure, be covered in great detail when the Honorable Home Minister replies to this discussion. But I picked up some gems, and I thought I will share them with you. It was when the Honorable Chairman was presiding that words that were used included retrogressive, unconstitutional, control freak, principles of federalism violated, arrogant government, accountability, constitutional stupidity, cheap tactics, chicanery. Now, I would like to subject some of these terms to any dictionary of legal usage or normal linguistic usage. And I think much of this actually is applicable to what is being said by those who are opposing the bill, rather than the constitutionality of what we have brought forward. But I think the gem which I really enjoyed, and I think, sir, I say this out of deference to you because you yourself are such a high legal luminary, that when lawyers start quoting from historical figures, they should be careful. When they came for the socialists, I did not oppose because I'm not a socialist. Then they came for the trade unionists. I did not oppose because I'm not a trade unionist. Then they came for the Jews, and I'm not a Jew, so I didn't oppose. Now they come for me. Sir, I want to humbly submit, they came for you. They first attacked you. And I'm talking about a period before the BJP government assumed office in May 2014. Let me remind you, because you seem to have selective amnesia. On the night of 15th and 16th of January, one of the so-called elected, accountable ministers of the Aam Aadmi government, a gentleman by the name of Mr. Som Bharti, he attacked a colony of foreigners, and he used a mob as an instrument of politics. Some foreign nationals were subjected to cavity searches. So that's a very serious term. Cavity searches, basic human rights violation. They were subjected to, they were subjected to urine samples were tested, and they said, I know the honorable Congress member is encouraging show, but let me complete. You don't know where you will have to look then. Let me remind you. Sit down, you'll benefit from this. And Honorable Chairman, sir.
One second, sir. Oh, no, first ask your colleagues to take the seat. 1 second. One second. First ask your colleagues to take seat. Yes. Now what is your point?
The point is, sir, because he is naming the person who is not a member of this house. How he can name that person?
Yes. Let me tell the honorable member, Mr. Gupta, that this issue was addressed by me on a point of order raised by the leader of opposition. And I had categorically held that this house has the power to discuss conduct of anyone. This house has the power to discuss anything under the planet. And as a matter of fact, this issue was signaled by former Chief Justice Mr. Gogoi also. If it is with respect to member of a Lok Sabha, then there is a set procedure that before making accusations, notice has to be given. So don't get upset. Don't get upset.
Mr. Chairman, sir.
1 second. Let me tell you, Mr. Gupta, if you get upset, you will be helping Mr. Puri. You will be helping Mr. Puri if you get upset. Please.
Sir, this unfortunate incident, which we would all want to forget, but which my friends, those who are opposing this bill, perhaps want to forget even more, took place on the fateful night of 15th and 16th January 2014. Sir, I wrote about it even then. I have a publication which has these and other such incidents documented. And these were, I can give them the citation, these were much before the BJP government under the leadership of the Honorable Prime Minister assumed responsibility. Sir, this did not end here, because the then so-called accountable Chief Minister, who did not succeed in persuading or using the margin of persuasion with the Delhi police force, then decided 3 days later to hold the entire city to ransom by going on a strike at Rail Bhavan for 36 hours. It was, sir, on the 20th of January 2014. And all he wanted was those 3 police persons who did not support that vigilante type of action against those foreign ladies, they should be suspended. And sir, because we had a government in power in Delhi at that point of time, they followed the policy of appeasement. They indulged this kind of behavior, and 2 of the policemen were transferred because they were afraid that the 26th January celebrations would be thwarted. Sir, these are the facts, and let me not stop here. This was an action in January 2014. Now, this bill speaks to the heart of governance. Heart of governance. What does governance say? Sir, what does the heart of governance say? And I'm very happy that my chance to speak came after my learned friend Shri Mahesh Jetmalani and others. But since I'm not a lawyer and I was preparing for this intervention, for which I'm deeply grateful to my party, there are 2 or 3 things which stand out. This particular insertion in 1991 and 239, what does it seek to do? It acknowledges the sui generis character of Delhi. The honorable member mentioned there was a reality. It is a union territory, yet it has a legislature, elected government. So he used the term escalated union territory. But that sui generis character needs to be acknowledged, it needs to be fleshed out, and that is precisely what the bill that the government has brought is seeking to do. Now, the civil service authority which is being established, I found it appalling that someone can get up here and say one member is the supreme. Yes, he's an elected chief minister. He deserves full respect. He deserves to have his position as primus inter pares in this 3-member committee acknowledged and respected. But to say that the other 2 are against the whole system, or they have been appointed and their integrity is in doubt, is an outlandish statement, if I may submit. Let me now read out to you how they treat their chief secretaries. Sir, I have in front of me the copy of an FIR filed a few months later. It was filed on 20th February 2018. The then chief secretary says that he received an information yesterday, that is 19th February. I was informed on telephone at 8:45 p.m. in the evening that the advisor to the Chief Minister, Shri V.K. Jain, that I had to reach the CM's residence at 12 o'clock at night. Sir, I'm not going to read out the whole FIR, but I'll read out some salient portion. He had already met the Honorable Chief Minister at that point of time, earlier in the day. He was to meet the Chief Minister again the next day because there was a cabinet meeting. And the contents of this FIR, sir, are amazing. He says he was told that if some advertisements that were the Honorable Chief Minister desired and some of their MLAs desired, if those advertisements are not released, he better come there at 12 o'clock. The Chief Secretary reached the Honorable Chief Minister's residence. He thought only the Deputy CM would be there, Shri Manish Sisodia. But to his surprise, 11 other MLAs were there. And they sat down and started questioning the Chief Secretary in an aggressive manner why those advertisements were not released. To which the Chief Secretary replies, as part of the FIR, part of the subsequent legal records, that those advertisements could not be released in the light of the Supreme Court directives. Then what happened is even more amazing. The Chief Minister and the Deputy Chief Minister are present, and the Chief Secretary is physically assaulted. Now, I am not surprised. I am not surprised.
Honorable member.
इसका जवाब आप जनता के सामने देना। आप भूलना चाहते हैं इसको, हम आपको याद करवाएंगे।
Honorable Minister, a copy of this FIR be laid on the table of the House.
Here and now. Okay. Now I want to come to the subsequent stages of what happens. Sir, initially when the case came up in the preliminary legal stages, the government of the National Capital Territory of Delhi took the view that no such incident took place. Total denial. When it went up to the next stage, they said, हाँ incident तो हुआ था, पर इसमें Chief Minister और Deputy Chief Minister ने हाथापाई नहीं की, उनके MLAs ने की हैं। साहब आप मुख्यमंत्री हैं, आपके घर में आप MLAs को बुलाते हैं, उनको कहते हैं Chief Secretary की पिटाई कर दो, तो ये कोई मैकेनिज्म नहीं चलेगा। ये इनको जनता के सामने जवाब देना पड़ेगा। और ये सब लीगल। Now let me come to a few substantive things, sir. I have had the privilege, sir, I have had the privilege of being Minister for Housing and Urban Affairs. Now,
nothing will go on record. Nothing.
Sir, I have had the privilege of being the Minister for Housing and Urban Affairs.
Members, I have heard from this side also, from every side of the House. One second, Mr. Gupta, you'll have to lend some ear to me and be a little patient. There have been inputs that have been absolutely beyond the bill. When I tried to request the honorable members to be in the groove, they said no. And I have had a number of them saying so. If the honorable minister is making an input, hear him patiently. When there is an occasion for someone from this side, you will have an occasion. But can we create ruckus in the House like this? So, no, I will not lend it. क्या कहा? ये झूठी FIR दिल्ली कोर्ट से खत्म हो गई।
Sir, let me shift now to a second segment of my submission to this august House through you, sir. I've had the privilege of being the Minister for Housing and Urban Affairs at least now nearly 6 years, sir, from 3rd September 2017. Sir, on many such occasions, I have had to appeal to the Honorable Chief Minister for the implementation of central schemes. When it came to the unauthorized colonies and their regularization, I had to write a letter to him. I'm placing that on the table of the House also, about the false narratives that they were creating. But let me come to some basic issues, sir. When it comes to schemes which have the Capital Territory of Delhi as an equal participant, let me give you, sir, something like the Delhi metro system. Sir, they are still sitting. There have been constant delays in getting approvals for metro and RRTS projects. The signing of the tripartite MOU for DMRC Phase 3 and Phase 4 for 3 priority corridors is pending despite several reminders to the GNCTD. Recently, sir, they are co-partners with us for the RRTS, and they would refuse to part with the remaining 415 crores. The matter was agitated before the Honorable Supreme Court, and the Supreme Court asked them, how much money have you spent on advertisement? So the reply given to the Supreme Court by the Capital Territory of Delhi government was that they have spent 1,100 crores on advertisements in the last 3 years. In 3 years. And they could not release 415 crores for the RRTS. So this again, एक ऐसा मुद्दा है जिसपे इनको दिल्ली की जनता को जवाब देना होगा. Or, so let me give you one or two other some examples, sir. A reference is already made in terms of dealing with institutional mechanisms. Let me also tell you, sir, that the 400 or so specialists or consultants who were hired, well, I'm very happy that the Lieutenant Governor has finally terminated their services. What services they provided at exorbitant salaries, perhaps they might like to inform the House about that. But there was another expenditure, sir, where they incurred 60 lakh का खर्चा किया कुछ इक्विपमेंट खरीदने के लिए. इक्विपमेंट 60 लाख की है और उन्होंने विज्ञापन उस पे किया 23 करोड़ के. I will place those facts in front on the table of the House also. Sir, circumstances. Sir, very often, we are told that the central government starves the government of Delhi and the MCDs and everybody of funds. I did a quick reckoning, sir. Since 2014, we have given to these different bodies under the urban development funds for other schemes a total of 52,052 crores, sir. 52,052 crores. And what we witness, जो हमारी केंद्रीय योजनाएं हैं, मैं इसलिए एक का उदाहरण दे रहा हूं क्योंकि मनसुख भाई मेरे साथ, my honorable colleague is sitting next to me. Some of the most successful schemes, sir. आयुष्मान भारत, जिसके तहत एक परिवार को एक वर्ष में 5 लाख रुपए की सुविधा है इलाज करवाने के लिए, दवाइयों के लिए, ऑपरेशन के लिए, पोस्ट ऑपरेशन केयर. ये इन्होंने दिल्ली में लागू ही नहीं की. इन्होंने कहा कि हमने शानदार वर्ल्ड स्टैंडर्ड के मोहल्ला क्लिनिक बनाए हुए हैं. वो हमारे कुछ लोग हैं, उनको शुरू में पसंद आते हैं, फिर वो समझते हैं कि यहाँ पे वर्ल्ड क्लास नहीं है, ये तो काफी फटीचर टाइप है, तो फिर उनकी निंदा कर देते हैं. देखिए सर, ये आपने एक शब्द इस्तेमाल किया, कन्वीनियंट मैरिज. कन्वीनियंट मैरिज क्या होती है सर? कन्वीनियंट मैरिज मेरे हिसाब से वो होती है जो एक अपॉर्चुनिस्टिक अलायंस होती है. तो वही कांग्रेस पार्टी जिनको इसमें वो लग रहे हैं, पहला अटैक तो आम आदमी पार्टी का उन्हीं के खिलाफ हुआ था. अल्टीमेटली इसकी पैदाश कहां से हुई थी आम आदमी पार्टी की? सर, it was we also welcomed it. I must say, as a private citizen, when I found a social movement headed by a highly respectable Anna Hazare against entrenched भ्रष्टाचार, entrenched corruption के खिलाफ. But today, you wonder who started the movement and who has become the prime mover and where is this leading to? So I make the submission to you, sir. I have no desire to take more time than is necessary because I told you I have already seen that most of the question and those absurd statements have already been responded to by others at the legal front, and I'm sure that the Honorable Home Minister, when he's responding to the debate, will provide. But in conclusion, sir, let me ask through you one question. Why do we have selective amnesia? कुछ चीजें हमें याद रहती हैं और कुछ चीजें हम कन्वीनियंटली भूल जाते हैं. अच्छा, शब्द जो इस्तेमाल करते हैं यहाँ पे, आपने कहा कि ये अनकॉन्स्टिट्यूशनल है, ये सब जुडिस है, ये है, ये वो है. मैं आपसे एक चीज सवाल पूछना चाहता हूं. अगर आपके पास लीगल आर्ग्यूमेंट्स नहीं है, तो चिदम्बरम जी ने बिल्कुल सही कहा कि लीगल आर्ग्यूमेंट्स हैव बीन एग्जॉस्टेड बाय डॉक्टर सिंघवी, तो इसलिए वो पॉलिटिकल करे. पर पॉलिटिकल आर्ग्यूमेंट भी मेरे को समझ नहीं आ रहा. ये चाहते क्या है? डू यू वांट द नेशनल कैपिटल टेरिटरी ऑफ दिल्ली टू बी सब्जेक्टेड टू दिस काइंड ऑफ एनार्किज्म? और ये एनार्किस्ट का शब्द मैं नहीं इस्तेमाल कर रहा हूं. जब रेल भवन में उन्होंने 36 घंटे he held the city to ransom, he said, and he's on record, I'll make that cutting also available, I am an anarchist. So this political formation, sir, a startup, has not made the transition from anarchy to governance. And this bill is about governance. They should rejoice, they should welcome it, and they should participate in mature governance till they are in office. बहुत बहुत धन्यवाद, sir.
Message from Lok Sabha, Secretary General.
Sir, with your kind permission, I rise to report that the Lok Sabha at its sitting held on 7th August 2023 has agreed without any amendment to the Mediation Bill 2023, which was passed by Rajya Sabha at its sitting held on 1st August 2023.
Honorable members, as you are aware, discussion on the Government of National Capital Territory of Delhi Amendment Bill 2023, which has been allotted 6 hours for discussion, will continue beyond 8 p.m. today. In view of the extended sitting, for the convenience of honorable members, dinner will be served in Banquet Hall, Parliament Library Building from 7:30 p.m. onwards. Members may accordingly make use of the arrangements. Dr. M. Thambidurai, 4 minutes.
Sir, I am former law minister. You have given so many people. I am former law minister.
Sir, the world is very cruel.
Give me some more time.
It takes note of the present.
No.
All of us have that feeling, you see.
Please, sir,
I was
this is a very
for
important
long
bill
time.
brought by Honorable Hamid Jaji. I want to support this bill. Give me some time. Because as a law minister, former minister, I want to say something.
Let me tell you, Mr. Thambidurai, you have been a former law minister.
Sir.
Whenever there is a bench of judges,
sir, you are
the wisest judge is one who says, I agree.
Time is please. Sir, you are a legal luminary. I am ordinary law minister at that time. You please allow me to speak.
4 minutes.
Sir, on behalf of ADMK party, I support the bill brought by Honorable Home Minister Amit Shah ji regarding to seek that to promote harmonious relations between the legislature and executive and further define the responsibility of the elected government and the lieutenant governor in line with the constitutional scheme of governance of the National Capital Territory of Delhi. Sir, you know very well the Article 1 of the Constitution of India defines the territory of India as comprising of states and union territories and nothing else. And Article 1 read with Article 239 provides that the union territories to be governed solely by the President. Sir, I want to make certain points because our eminent lawyers, Abhishek V. and Chidambaram, they argued about the bill against that. They are the eminent lawyers. If they come this side also, they will defend the bill also. They have the capacity. Therefore, as lawyers, they made their points. That is different, sir. But the crux of the point what they said regarding the federalism and the rights of the union territory, the union state governments and union territories, everything they argue. I want to know what is the present status of federalism? Who is responsible for decentralization of this government? This is your government, Congress government. The Congress government, they are responsible for this kind of anarchy and take away the state rights. That is, everybody knows that. Especially 1976 emergency period, nobody can forget the Indian history. How this former Prime Minister Srimati Indira Gandhi ji, how she brought certain rules and taken the state powers, including education.
Same.
Who did it? But whether central government did anything for that? But if they thought they would have brought, even DMK was afterwards, coincided with the government so many times ruled, if they have told, they have brought once again education to the state subject. But they have not done. Because why I am telling, the federalism, everything is gone arguing. When they are opposition, they are arguing for federalism. When they are coming to the power, they want to decentralize, hold the power. These are the things that are happening. And centralize, they are centralizing. This is the power, sir. Sir, just now I started,
1 minute.
sir.
1 minute, 1 minute.
For example, even finance, sir, who brought the GST thing? Because our DMK government is criticizing GST. We are also against that. Who brought that? But Chidambaram only finance brought that. See, all like that, there are so many times, sir. And also, because you are going ringing bell, I want to crux up the point. I don't want much of the time. Because I am supporting Amit Shah ji, what he has brought. See, because what they said, why the special status only for Delhi? We are demanding for Pondicherry has to be given the statehood. Whether they have given, whether Congress has given, they are not given. But because of the peculiar situation and based on the Supreme Court judgment, now the Honorable Minister has brought it to see that protect the interest of the
GK
just I am finishing, sir.
4 minutes.
Sir, I am finishing. I am finishing, sir. Parliament, they are telling who are the people. This Parliament is Parliament is responsible. The elected people. We are enacting the bill. We are responsible. Given the governor is taking any decision,
GK
the Home Minister.
Shri GK Vasan, thank you. Shri GK Vasan, 4 minutes. 4 minutes.
Sir, I stand here to support this important bill, sir. Sir, I want to echo the views of common public in Delhi, sir. Delhi being the capital city of India, sir. Delhi public feel this is a symbol of India, sir. The bill, sir, they feel it is necessary to balance the welfare of the people in Delhi, sir. This act is required to balance both local and national interest in the capital city with democratic will, sir. More than that, sir, the status of NCTD cannot be equated with other union territories with legislature, sir. Therefore, the people feel center has a much bigger stake over legislature in administration and enforcing law and order in the NCTD, sir. Sir, most important, sir, this bill is also inconsistent with Article 239AB of the Constitution, which empowers the President to make regulations for the peace, development and good governance of the Delhi, sir. Sir, this bill, sir, will also be essential for public order in Delhi, security in Delhi, administrative improvement in Delhi. To conclude, sir, I would like to say narrow political opportunism cannot take precedence over good governance and national security at large, sir. Therefore, my party strongly supports this bill. Thank you, sir.
Shri Bhuvaneshwar Kalita, not present. Shri Javed Ali Khan, 4 minutes.
Yes, sir. माननीय सभापति जी, मैं दिल्ली राष्ट्रीय राजधानी राज्य क्षेत्र शासन संशोधन विधेयक 2023 के विरोध में खड़ा हुआ हूं। आज का दिन हमारे लिए बहुत मधुर रहा। बहुत सारे वकीलों की बात भी सुनी और जज साहब की बात भी सुनी, सीनियर लोगों की बात भी सुनी और कुछ जो हमारे बाद सदन में आए थे उनकी बातें भी सुनी। एक बात बड़ी प्रमुखता के साथ उस तरफ के साथियों ने उठाई, मुख्य सचिव की पिटाई का मामला। एफआईआर हुई, आपने टेबल करने के लिए कह दिया। मैंने ये निवेदन किया था अपनी जगह से बोलते हुए, शायद आपने सुना नहीं, कि उस केस का हश्र क्या हुआ, वो फैसला भी कोर्ट का टेबल कर दिया जाए, क्योंकि उसमें किसी के ऊपर कोई कार्रवाई नहीं हुई सर। वो मनगढ़ंत केस रखा गया था, झूठा साबित हुआ कोर्ट के अंदर। पुरी साहब कहते हैं कि कन्वीनियंस के हिसाब से बोल लेते हैं लोग, आधी बात छोड़ देते हैं, आधी बात कह देते हैं, जो मतलब की होती है वो कह देते हैं। उन्होंने भी ठीक यही किया है कि अपनी कन्वीनियंस के हिसाब से आधी बात प्रस्तुत कर दी और जो उस कोर्ट केस का हशर हुआ था उसके बारे में उन्होंने भी कुछ नहीं कहा।
I direct you to place that judgment on the table of the house.
Okay, we will do, sir.
Go ahead.
पर अपील हुई है वो भी रखवाई, जजमेंट फाइनल नहीं हुआ है, अपील हुई है हाई कोर्ट में।
And honorable members, I had indicated on number of occasions, this house, this house cannot be a platform to set afloat narratives which are not factually tenable.
सर मैंने तो
You
कोई
have
गलत
made
बात-
an assertion in the House
मैंने अभी तक
and
कोई
you have
गलत
not
बात
given a complete picture.
कोई नियम
I
विरुद्ध बात
direct you to put it on the table of the House.
मैंने कोई
Go
गलत
ahead, go
बात
ahead.
कोई नियम विरुद्ध बात तो कही नहीं है सर हम तो आपका रोज ही सुनते हैं जो आप हमें
We
बताते
have
हैं
to
हम
do
मानते
our
भी
due
हैं
diligence. One second. We have to do our
Sir,
due diligence.
sir, सारी
We have
बहस
to do our
सुनने के बाद-
homework and then come to the House. Go ahead.
सर सारी बहस सुनने के बाद और भारतीय जनता पार्टी की तरफ से जो बातें कही गई मैं इस नतीजे पर पहुंचा कि ये उम्मीद छोड़ चुके हैं कि ये दिल्ली में कभी वापस सरकार बना पाएंगे इसलिए दिल्ली पर हुकूमत करना चाहते हैं जिस तरीके से भी हो ये चीफ सेक्रेटरी की बात करते हैं सर उत्तर प्रदेश के अंदर मैं नाम नहीं ले रहा हूं गृह मंत्री जी अगर चाहें तो मैं नाम भी ले दूंगा एक सांसद ऐसा है जो हर हफ्ते तो नहीं हर महीने एक ना एक अधिकारी को पीटता है ना उत्तर प्रदेश की सरकार कुछ कर पाती है ना गृह मंत्री जी उसके खिलाफ कुछ कर पाते हैं और चीफ सेक्रेटरी जिसका केस भी कोर्ट ने खत्म कर दिया उसके लिए हाय तौबा मचाए हुए हैं
Honorable member, you have made a serious assertion.
Yes, sir.
Entire documentation,
Yes.
which
I
is
have many
legitimately
press cuttings. I
in
have
public
many
domain,
press
be placed
cuttings.
on the table of the House.
I have many press cutting of
Pla-
an MP.
Place it on the table
I
of,
will.
of the House
I will.
during
sir.
course of the day.
Sir.
During course of the day. Please, Professor, sit down.
Sir.
Professor. Professor.
Sir.
We cannot allow free fall of information.
Sir, एक बात
No,
भी ऐसी
this
नहीं
is,
कहूंगा।
this is not a platform or ground for accusation.
Sir.
Mr. Gupta.
सर एक बात भी ऐसी नहीं कहूंगा जिसका
Mr. Gupta.
सर एक बात भी ऐसी नहीं कहूंगा जिसका साक्ष्य
So I take it. Yes, that's all I said. I don't know why other members are agitated. Dr. Keshav, I am surprised why the members are agitated. The honorable member is prepared to lay it on the table.
Yes.
I said during course of the day. Take your seat. Take your seat. Take your seat. All of you take your seat. Take your seat. Take your seat.
सर इस बिल के पास होने के बाद मुझे ऐसा लगता है अब इसका डॉक्यूमेंटेशन मत मांगिएगा सर वो मैं दे नहीं पाऊंगा
I will, if that is required. Think twice. It has serious consequences.
ओके सर सर लिसन भाई इस बिल के पास होने के बाद मुझे ऐसा लगता है कि उपराज्यपाल का पद भारत के किसी भी राज्य के राज्यपाल के पद से भी ज्यादा ताकतवर हो जाएगा अब इसमें कोई डॉक्यूमेंटेशन की जरूरत है नहीं सर है क्या
इसमें नहीं है
इसमें नहीं है और मुख्यमंत्री की हालत दिल्ली के एक नगर पंचायत के चेयरमैन से टाउन एरिया के चेयरमैन से भी गई गुजरी हो जाएगी लिहाजा मैं बीजेपी के साथियों को और सरकार को यह सजेस्ट करना चाहता हूं कि आप इधर उधर की बात मत करिए अगर आप सही सोचते हैं कि दिल्ली में बहुत गलत शासन चल रहा है तो दिल्ली की विधानसभा को ही खत्म करके यहां इसको नगर पालिका या महानगर पालिका जो बनाना चाहे बना दीजिए मेरा कुछ टाइम खराब हो गया था सर बीच में बातचीत
Accommodate कर लिया है
Accommodate कर
That
दीजिए
time has been accommodated.
No, it has to be accommodated.
It
Sir,
started late. Shri Bhubaneswar Kalita.
सर मेरी बात
Shri
Thank you. Thank you, Honorable Chairman, for giving me this opportunity to speak on this very, very important bill on the government, on this amendment bill. Sir, some of the questions, the opposition members has raised few questions on the unconstitutionality and morality and the undemocratic nature of the bill. So that all has been tackled and handled by our jurists like Maheshjat Malaneji, Justice Gogoi has very well explained the constitutionality of this bill, and I think our friends in the other side will be satisfied with that. So I will not go much into that. I only want to explain certain things which has come from the opposition members. and some of the members have, and most of the members are comparing with their state. Like Tamil Nadu, like West Bengal or Bihar, they are talking about a state. But here, in this bill, we are not talking about a state. Because Delhi is not a state in the true sense. It is national capital territory, and it falls under special provisions mentioned in Article 239 to Article 242 of the Constitution, The Article 239AA 3B grants Parliament the authority to legislate for Delhi and its related matters. Delhi's government functions according to the procedures outlined in the Constitution. It is a unique administrative unit with specific legal provisions governing in governance. So it is a completely different case. It's not like any other state that they are comparing and they are making their statements. So the question that was raised by was about Supreme Court, that this is pending in the Supreme Court. So the matter which is pending in the Supreme Court is different. The issue is different, and this is a different issue. The Supreme Court explained that the Union government wants control over certain services. A new law is needed. That is what the Supreme Court says. This new bill is being passed to make that happen. The entity with the authority to create laws and rules is the same one that can make rules under the Act. In this case, it's the Union government. So here I want to point out certain things which has been raised by our friends in the opposition, in the other side. So they say that the bill is undemocratic. So the bill is not undemocratic. Had it been undemocratic, it would not have come in the parliament at all. So, and what kind of democracy they are talking about? The democracy, the legislature which is functioning in Delhi, the Legislative Assembly of the NCT of Delhi is unique as it does not experience prorogation. In 2020, there was just one session. So, just one session in 1 year, comprising 5 brief sittings over 2 days, solely for budget purposes, for the passage of the budget. Similarly, sir, in 2021, 2022, 2023, only one session each took place, all centered around passing the budget for the respective fiscal years. So they talk about democracy, where the legislature doesn't sit. It sits only once in a year to pass the budget. So another thing that it is in the knowledge of them and us all, that the infrequent convening of cabinet meetings. You see, in a democratic government, cabinet is supreme and cabinet has to be taken into confidence. But here, the cabinet, both in 22 and 2023, primarily cabinet was summoned to address budgetary concerns. This approach of the government is seen as problematic, as it may impede effective administration and decision on implementation. Notably, the absence of crucial actions such as presenting Comptroller and Auditor General report, which is a constitutional obligation, for the past 2 years misses the questions about the transparency and accountability. So, when the cabinet doesn't sit, when the assembly doesn't sit, where CAG report cannot be placed, where is the transparency and accountability? So, as we all see that in this, in the authority, one of our members said that CM's position has been made redundant. Sir, that redundancy is what I want to explain here, sir,
the backlog of crucial files pertaining to prominent institutions like Regional Rapid Transit System, AIMS, the IIT Delhi, indicates a lack of expeditious decision-making within the government of NCT Delhi. These delays have raised concerns about the pace of development and implementation of essential projects. So they are not interested about these projects, which are for the people, which are for the benefit of the people. But they are not interested in this. Our Honorable Minister for Housing has eloquently explained about that, so I need not repeat that anymore. Sir, today's world is going ahead towards the modernization. But here we see, while a 5G technology initiative was accepted by numerous states, including our many states, including those ruled by different parties, the NCT of Delhi has refrained from endorsing it, citing its perceived lack of relevance in the city's development. So, sir, they are not interested in public work. They are not interested in work of the digital world. They do not want 5G. So, what they want to say? What they want? They want only power. The bill for them is power. Because that the Chief Minister power has been clipped. So that is their objection. That is their complaint. Sir, this bill is not of power. This bill highlights the plight of the people and to make the life easy for the Delhiites and the capital. Sir, we all live in this capital. We all MPs will live in this capital, and we all see what kind of. The other day, one member has said that there was water shortage. Why? The water shortage was because of flooding. So, 9 years of this government, the flood problem has not been solved. Sir, we remember, if we all remember, during the COVID pandemic days, there was shortage of oxygen. Why? 8 plants were granted to Delhi government. 8 oxygen plants were allotted to government of Delhi, but they did not put up those plants. 1 or 2 they have put up, others were not put up, and that's why there was oxygen shortage. But for that also, they blame the government of India, the central government. So, sir, I want to support this bill with all my support. And this is a very important bill, and this bill should be passed unanimously. That is my appeal. Thank you, sir.
Shri Santosh Kumar P, 4 minutes.
Thank you, Chairman, sir. I take this opportunity to oppose this undemocratic, anti-federal, unconstitutional bill introduced by the Manipur Shame Union government. Sir, if you go through the pages of history, one thing can be easily understood. That one organization, I don't want to name it, based on Nagpur, was from the very beginning itself opposing the concept of federalism. They thought the concept of federalism is actually anti-Indian, so they always stood against that concept. And I think my party, the Communist Party of India, thinks that this attack in the form of this bill is a new addition to that continuing attack on federalism. And I would like to ask the Honorable Home Minister, who is present in this august house, the statement, objects and statements, a detailed list is given. It is stated that any decision taken or any event happening in the capital of the nation not only affects the residents, and many things are stated, and national reputation, image, credibility, and prestige at stake in the international global spectrum. So I would like to ask you, Mr. Home Minister, can you cite even a single incident, single example to justify your position. You are insulting the people of Delhi. The democratically elected government, is the democratically elected government of Delhi is responsible? In any of the international forums, anyone discuss about these issues? Unfortunately, so as to say, the international community is discussing about Manipur. I am sorry to say, the treasury benches were vocal against the failure of the Delhi government. May I ask you, it was the European Union Parliament which discussed about one particular Indian state. I don't want to name that because that will create problems here. They don't want to hear the name. More than 6,500 cases were registered, FIR. Not even 500 were arrested. So, in one state, your government have failed like anything, and now you are blaming the union territory and its government, Delhi government. So it is so shameful from your side. And let me ask you one more thing. There are many provisions which is unconstitutional, anti-federal in this. Because of the shortage of time, I don't want to mention more. Let me ask you one important question. Most of you people may be indebted to the BJP recently because of many factors. But at least you should learn the history of BJP political party. As a political party, BJP once upon a time stood for the Delhi statehood. Full statehood. Advani, LK Advani, the forgotten hero of your party, in 2003, drafted a bill suggesting the full statehood of Delhi. And what is your position now? Why you are forgetting all these things? And this thing, this Delhi bill actually makes the Chief Minister's position fourth. First, the Lieutenant Governor, secondly, the Secretary, third, another officer, and the fourth one is Chief Minister. And what a shame is that. So why we need a democratically elected government in Delhi? Amit Shah could have brought with a new bill suggesting the abrogation of the Delhi administration. This was the best thing. This was the best thing. So this is an insult to the democracy. And let me tell you, sir.
Conclude, please conclude.
Yes, I am going to conclude. Some of our friends, especially from Orissa and Andhra Pradesh, were very vocal today. ED might have knocked more on the doors today, but we are not fearful of the ED. We oppose this bill. This is anti-India, anti-democratic. So we appeal all of you to oppose this bill.
Dr. Anil Jain.
धन्यवाद सभापति महोदय.
10 minutes.